Life is pain. Life is pain. Audio sounds good. I haven't adjusted the level since last time. I'm gonna go straight into it. I'll be sure to monitor audio a few times in pursuit of not accidentally going with no audio. This channel is called The Quiet Part. And it's called that because I used to think the idea of saying the quiet part out loud was like really interesting, right? When politicians would very clearly be lying, and they would just kind of accidentally tell the truth if they were asked the right question or around the right crowd. Sometimes they would just come out and say it. And I think the objective reality, beyond any degree of doubt, and without regard for any amount of obfuscation, I think the objective fact is that the American right, politically, not in terms of voters, constituents, but in terms of the political leadership, the American right is an institution of death and war, and they should all be charged with treason. Prisons are stupid. We shouldn't hold people in prisons. They should be charged with treason and then put back out on the street and allowed for people to deal with them on their own. If you weren't here last time, this document I'm reading has nothing to do with the war that is about to happen between the United States of America and the country that is called Iran. I think it's also a state in that sort of sense, right? The state of Iran, just like the state of Israel, just like the state of France. We get news every single day of how disgustingly bloodlusted Republicans in America are. I don't know. It's not sobering anymore. It's mind-numbing. Like, it's not like, oh, this made me sit forward in my seat and take things seriously. It's like, oh, sure. Like, what else are you gonna throw on the table, right? You're gonna put out a document officially saying that trans people are not a protected class because they don't fit in your understanding of the gender binary, the sex binary. You're gonna say trans people aren't people. You're gonna say, depriving pregnant women of health care is fine because, not all women have to get pregnant, and that's not sexist. You're going to do all this batshit evil stuff. You're going to be... This is all hearsay, but right before the stream, the reason I started by just talking about the warmongering of the American right leadership, I think, contrary to their constituents' well-being, I'm pretty sure that most Republicans on the right, genuinely, more than half, probably don't want a war where they have to get drafted into it. They probably don't want a war where there's a threat of nuclear holocaust. They probably don't want that. So the leadership on the American right is so bloodlusted and so evil and disgustingly unbothered by death and war and violence, aggressive violence, that we're hearing reporters, and this is all hearsay as of today, which is Friday, June 20th, the day after Juneteenth. Shout out American history and the people who fought to make sure the southern states knew that emancipation had happened. Shout out to the entire ancestry of anti-war, of pro-egalitarian, of pro-human liberation movements throughout human history. It has been a good run, and I worry at this time. this is all hearsay, but I was just reading some reports, shit that's coming out of Twitter and all this dumb shit and Blue Sky, which, God, that just feels unreliable, but that's how it is now. Reports from actual foreign policy focused, White House focused journalists being like, hey, the executive branch of the United States and the leadership, Trump, is considering just going all in on an illegal offensive war with the state of Iran. And, they're using language like, oh, everything's on the table, right? Nothing's off the table. We're, everything's an option when fighting these guys. And, when pressed about like, oh, that doesn't mean nukes though, right? Silence. It's like we just live in this incomprehensibly dystopian world. And in a live stream, I don't know if I should really be recounting this, but back during the Biden presidency, when the world seemed a little bit more stable for the U.S., right? Let's acknowledge my own myopia. Palestine wasn't doing good. They were still being genocided by the state of Israel. Since then, my positions on things like accelerationism and how I feel towards the concept of collapse are changing. And I think that's good and fine. I think it's good for me to not be married to my beliefs because historically, that is what has kept me being reasonable. I think that the world is probably headed towards some sort of collapse right now. Or at the very least, the proximity between where we are now and what collapse looks like, the proximity between those two worlds is so close that my former position towards the idea of collapse and this whole doomerism mindset, my position is changing because this is a very obvious and real risk. Now, I knew that there was always the threat of any country starting a nuclear holocaust. I always knew that was possible. I'm pretty sure everyone has had that looming over their heads for a long time. But now we have people in leadership that, like, are okay with it. And that's a completely different ballgame. So, yeah, I think the United States might be in, like, free fall at this point. And with that, I used to be an incrementalist. I'm like, no, I want to slowly see change in life and in the world. I don't want a violent political revolution. That would be bad. People would get hurt. And now, it's not that I suddenly want a violent political revolution. It's what the fuck else is the option? It's practically like the entire world is being forced into a violent political revolution. In the same way that the riot is the language of the unheard, so too will the revolution. Because, I mean, what the fuck do you do in the face of this? You had a Supreme Court that just ruled that trans people aren't people. You have a president who's edging total atomic annihilation with random fucking countries that we should have nothing to do with, all while already dedicating tens of billions of dollars to funding Israel's genocide on people next door to that. $150 billion increase to the big beautiful bill. Removing legal immigrants' access to the same healthcare tax credits as all other normal fucking white people, because we know this isn't about white immigrants. So, just seeing all those things happen at the same time, back to back to back, it leaves me thinking, like, okay, I have tried not to entertain the doomerist mindset of like, oh, things are collapsing, we need to prepare. I've tried not to entertain that mindset because I wanted to virtue signal a position of hope, of solidarity, of a solar punk world where things can be better, and we will make them better. But I think that sticking to that position is not conducive to my actual goals of a better world, because we don't have that stable, slow world right now. We have the fast one. We have the accelerationist one right now. And so the solar punk position should be, if I really want a better world, is that I will take what I am given and I will run with it. And if what we are given is a violent political revolution paired with global societal collapse, then I'm fucking running with it. If I'm given bureaucracy and stability, then I'm running with that. Whatever I'm given, I'm going to have to run with. And right now, my brain is slowly shifting and adjusting to the fact that we are definitely in the accelerationist timeline and facing collapse. So, just random thoughts about the illegal war that's about to take place in Iran under the authority of the current United States. So much for anti-war, pro isolationism Trump. Come on. Fascists do what fascists do. All right, we are now reading and continuing to read the Supreme Court of the United States official opinion document on a case called the United States Petitioner versus Jonathan SKRMETTI, the Attorney General and reporter for Tennessee. This is the trans erasure bill that the state of Tennessee put forth something called Senate Bill 1. I believe it was SB 1. Yeah, there you go. It says SB 1 right there. So the state of Tennessee put together this Senate Bill 1, which amended some different things to make it such that gender dysphoria, gender incongruence, and gender identity disorder are no longer valid diagnoses that would enable a healthcare provider to offer minors hormonal or surgical gender affirming care. That is what the Senate Bill 1 out of Tennessee would do. The Supreme Court ruled that it is, yes, constitutional for a state to ban, in practice, this is what's happening. No, this is what's happening legally, to ban the validity of a diagnosis in an attempt to withdraw access to health care to those with that diagnosis. The Supreme Court is saying that's allowed. We all know in practice that the purpose of this is trans erasure. It is to invalidate the trans identity. It's to deny the trans identity. It is to remove transgender people's access to health care as minors. This is a dog shit bill. I have read more than half of it. We are now starting on Justice Alito's concurrence, because the final decision, I believe, was 6-3, and sometimes individual judges will write their own little "here's why I agree, here's my reasoning" statement, and that's what we're reading from Alito. And then I think there'll be one or two more, maybe Kavanaugh, and then I believe we'll get to hear the dissenting opinions, which will be much easier to read because I will agree with them probably a lot. Previously, we were doing a speed run to see if we could get linked to crossdress because we were celebrating the trans identity and trans rights. I've already gotten linked to crossdress, so I might just start playing the game at this point, but I don't really know where I stand on that because I can't just keep playing Zelda forever, can I? Let's read.
Syllabus. Note, where it is feasible, a syllabus, headnote, will be released as...
Hey, when it does that to me.
Justice Alito, concurring in part and concurring in the judgment. I concur in the judgment and join parts 1 and 2b of the opinion of the court. I agree with much of the discussion in Part 2A1, which holds that Tennessee's Senate Bill 1, SB 1, does not classify on the basis of sex, but I set out my own analysis of this issue in Part 1 of this opinion. I do not join Part 2A2 of the opinion of the court, which concludes that SB 1 does not classify on the basis of transgender status. There is a strong argument that SB 1 does classify on that ground, but I find it unnecessary to decide the question.
Oh, weird. Alito's saying that maybe transgender people could be a protected status. Interesting, Alito. A ball. I'll take it, man. Like, whatever.
Question. I
But
would
he
assume for the
just
sake of
doesn't
argument
think
that
it's
the
the
law
right
classifies
scope.
based on transgender status, but I would nevertheless sustain the law because such a classification does not warrant heightened scrutiny. I also do not join Part 2A3 of the court's opinion because I do not believe that the reasoning employed in Bostock v. Clayton County, 590 U.S. 644, 2020, is applicable when determining whether a law classifies based on sex for Equal Protection Clause purposes. Opinion of Alito, J. I.A. To begin, I agree with the court that SB 1 does not classify on the basis of sex within the meaning of our equal protection precedents. What those cases have always meant by sex is the status of having the genes of a male or female. That was the common understanding of the term in 1971 when the court, in Reed v. Reed, 404 U.S. 71, 74, first held that a law that discriminated against women violated the Equal Protection Clause. See, e.g., Random House Dictionary of the English Language 1307, 1966, defining sex as the fact or character of being either male or female, Webster's Third New International Dictionary 2081, 1966, defining sex as one of the two divisions of human beings respectively designated male or female.
Designated.
And all the court's subsequent cases in this line have shared that understanding.
Yeah, but designated, that alone is contrarian to your definition.
S. 677, 1973, which was handed down in the next term after Reed, a plurality referred to sex as an immutable characteristic determined solely by the accident of birth. For 11 U.S. at 686. 25 years later, Justice Ginsburg's landmark opinion for the court in United States v. Virginia, 518 U.S. 515, 1996, VMI, exhibited the same understanding. The opinion observed that the physical differences between men and women are enduring, and that the inherent differences between men and women are cause for celebration. ID at 533. While the earliest cases in this line referred solely to discrimination.
If the differences between men and women are cause for celebration, then why don't we celebrate trans people attempting to have their identity legitimized so they can live as the people they want to be? So there's that. Right, there's the biological determinist perspective on transgender, transmedicalism or so, where it's like, you know, a trans person is literally trying to become the opposite sex. We should celebrate that that person is getting to be who they want, and that what they want is one of the biological sexes that you love so much, the binary. And then there's just moving beyond. The definition of sex has evolved, and one of the issues too is how they're using it is so. It doesn't align with the etymology of how sex was used by actual biologists and scientists, right? Sexes are just really a thing you focus on for like sexing an animal when you're observing it. Like, oh, which of the common phenotypes is this one? Right? Sexual dimorphism. Like, which one is this one? Is this the bird, the male, or the female, right? But then you get complicated. You talk about sex or sex organs or sex cells of plants. And then plants get complicated as fuck, where genetically they could have sexes that are, you know, 3 and 4 and 5 different sexes. Even if they use certain anatomy the same, genetically they could be different. It's obvious that the Supreme Court, unsurprisingly, is constantly behind the rest of the world in that they are not updating their definition of sex with the same realization that the world has had with gender, which is that sex is also a social construct. Sex is a social construct, gender is a social construct, and trying to define it perfectly is a pointless pursuit, especially sex specifically, outside of the medical field or the scientific field or the studies and the academics. What should matter is the practicality of the thing. You know, if separate bathrooms are a thing in the United States because of a history of homophobia and sexism and rape culture, then I mean, if someone passes, let them go piss wherever they're gonna piss. Like, just, yeah. Or, you know, the United States should obviously just transition to fully private stalls like every other civilized country. Yeah, sex is a social construct. These guys are too stupid to understand that. They will forever be 50 years behind the rest of the world. And I'm not conflating sex with gender. I'm saying gender is a thing, and it's a social construct. I'm saying sex is a thing, and it's also a social construct. It's just one that's more based in empiricism and science and biology as opposed to based in culture, psychology, and sociology. So one of these words describes the thing in science. One of these words describes the thing in sociology. One of them looks at determinism. The other one looks at
mind solely by the accident of birth.
Sociology and psychology.
686. 25 years
All right,
later,
here's what I'm going to do. I'm going to try to
Ginsburg's
defeat a divine beast while listening, which is this one's hard.
Virginia, 518 U.S. 515.
This is going to be hard. I'm going to fuck up a lot.
Exhibited the same understanding.
No way I won't mess up this. I don't think this fits her head. Why does it keep stopping? I have to be able to read.
Syllabus.
No, don't do it. Don't do it. Don't do it.
Ion for the court in United States versus Virginia, 518 U.S. 515, 1996, VMI,
No, it
exhibited
keeps
the
falling
same
off. That's
understanding.
hilarious.
The OPIN.
Why does it keep stopping at the word upin? Read.
While the earliest cases in this line referred solely to discrimination on the basis of sex, see e.g. Read 404 U.S. at 75 to 77, Frontiero for 11 U.S. at 682 to 688, plurality OPIN. Ion, later equal protection cases referred to classifications based on gender. See Craig versus Boren, 429 U.S.
Oh, I don't have a
190,
shield out.
192, 1976. But it is clear that these cases used gender as a synonym for sex. See e.g.
Yes, there was a point in time when the American popular culture used those words interchangeably.
Gender. Opinion of Alito, J. In this way, our
Follow
opinions
you.
track
I'm
the
not
change
following
in
you.
usage
You're
in
supposed to
ordinary
follow me,
speech.
bro.
As the Oxford English Dictionary explains, as sex came increasingly to mean sexual intercourse, gender began to replace it as the usual word for
Yeah,
the
because it
biological
started to
grouping of
become
males and
a
females.
verb.
Oxford English
That was an
Dictionary,
American
3D
English
edition,
issue.
June 2011, https://doi.org/10.1093/https://10.1093/https:///.
Do you see how fucking awful it is to do this stupid quest?
Thus, our use of the term gender had no substantive significance. None of our equal protection decisions has used gender in the sense in which it is now sometimes used, i.e., to denote a group of people in a society who share particular qualities or ways of behaving. Which that
So they
society
acknowledge
associates
that
with
the
being
word
male,
gender
female,
exists.
or another identity. 1. For these reasons, a party claiming that a law violates the Equal Protection Clause because it classifies on the basis of sex cannot prevail simply by showing that the law draws a distinction
Yes,
on
because
the
the
basis of
14th
gender
Amendment
identity.
focuses on
See
sex
e.g.
and not on gender.
Merriam-Webster's Collegiate Dictionary 520, 11th edition 2020, defining gender identity. Rather, such a plaintiff must show that the challenged law differentiates between the two biological sexes, male and female.
Okay.
B1.
All right, I'm gonna do it. I'm gonna
What,
pause
then,
so I
does it
can
mean?
get into this stupid thing. Yeah, I don't know what the fuck I was supposed to do about that when you immediately dipped out of the way while I was trying not to die. I generally find that uncool of you, and I don't appreciate that you chose to do what you just did. Okay, yeah, I am just gonna lock in and do this real quick. Well, the only option is to use a duplex bow. Reach, you do not turn while I am in the middle. What fucking foot am I missing right now? Bonk. Was that it? There's no fucking way that I only need to shoot 4 times. Nah, that was... this game doesn't make any sense to me. It gets
Mean
too
for a
easy
law to
sometimes.
classify based on sex. The succinct answer is that a law classifies based on sex for equal protection purposes when it p. Res crib es. 1 rule for women, and
another for men.
Sessions v. Morales-Santana, 582 U.S. 47, 58,
My controller is going
2017.
crazy right now.
And as we have explained, the general rule is that a law meets this test if it employs an overt gender criterion. Craig, 429 U.S. at 198.
Good job, Riju.
A few examples illustrate
I'm still
the
dressed
point.
as a girl, I forgot.
A law setting 1. 1
Now,
C
Boris.
Cambridge English Dictionary, 2025, https://dictionary.cambridge.org/us/dictionary/english/.
Fuck it up, Link! Fuck it up!
Opinion of Alito,
Fuck it
J.
up!
Drinking age for women and another for men is a sex classification. ID at 191 to 192, 197 to 199.
Okay, again, they're gonna be
A college
like, well,
policy
the
granting
issue
admission to
is the
women, but
14th
not to men,
Amendment is
or
written
vice
about
versa,
sex and
is a
not
sex
gender,
classification.
so we get to
Mississippi University
discriminate
for
on
Women
these
versus
people
Hogan,
that definitely
458
literally
U.S.
exist.
718, 720 to 723.
They even said, what do they say, like 3%? 3 million people are trans in the
A
U.S.?
law imposing different citizenship
1%?
requirements for children with citizen fathers compared to children with citizen mothers is a sex classification. Tuanon Nguyen v. INS, 533 U.S. 53, 59 to 62, 2001. What is apparent in each of these cases is that sex serves as an explicit criterion, dictating that a particular legal standard applies to one sex but not the other. See also Weinberger versus Y. Zenfeld, 420 U.S. 636, 1975.
You know, I gotta play-
Different rules for husbands
I gotta
and
play
wives.
Shadow of the
Stanton versus
Colossus.
Stanton, 421.
Which clearly inspired
US
like
7,
half of this.
1975. Different rule for men and women, Califano.
Right,
V.
so now I get
Goldfarb,
to see her
430
mom.
U.
Her mom
S.
ghost.
199, 1977. Different rules for widows and widowers.
W voice?
Califano versus Webster, 430 U. S. 313, 1977.
That is exactly
Mercury,
what she would
different rule
say.
for men and women, or versus or, 440 U. S. 268, 1979. Different rule for
Now
husbands
let's
and wives.
see, what is the
Gabon versus
chance that I
Muhammad,
have started to
441
memorize
U. S.
these
380,
dungeons
1979.
after doing them like
Different rule
20
for unwed
times?
mothers and unwed fathers.
Oh, okay, I'm
Ruler versus
remembering
Turkish
this.
smut.
I am remembering
Inns
this.
Company, 446 U. S. 142, 1980. Different rules for widows and widowers. Kirkberg versus Feenstra, 450 U. S. 455.
Okay, so he's just
1981. Different rule for
right.
husbands
Again,
and
they
wives.
always do this
Morales
thing
and
where they're like,
Tank,
"I'm
582
bound to the
S.
law.
47.
I
Different
simply
rules for
must
unwed
interpret
mothers
it
and
to the
unwed
letter."
fathers.
But it's like, also trans people are fucking
In contrast to
stupid,
what
and
our
I
cases have
hate
demanded, we
like
have
that's.
never suggested that mere reference to sex is sufficient to
This
trigger
is what I
heightened
hate
scrutiny.
about all this crap.
Ante, at 10, citing Win, 533 U.S. At 64, see also Dobbs versus Jackson Women's Health Organization, 597 U.S. 215.
I remember how much I
236
used to hate
237,
fighting the
2022,
lightning
holding
blight
that rational
Ganon or
basis
whatever.
review applied to a prohibition on abortion, despite the fact that the law in question mentioned the physical health of the mother. We have also explicitly rejected the proposition that a law. Opinion of Alito, J. classifies based on sex when it employs a non-sex classification that correlates with differential treatment of men and women.
Right.
In Geduldig versus ILO,
Yep, in ILO,
S.
the California Insurance Program.
1974. For
Well,
example,
they're
we
not
considered a
discriminating
California
on
insurance program that
the
exclude
on
D
their
from covered
sex. They're
certain
just
disabilities
discriminating
resulting
on the
from
thing
pregnancy.
that's like tied
ID
to their
at
sex,
486.
kind of literally and
Although we
directly.
recognize that only women can become pregnant, we explained that it does not follow that every legislative classification concerning pregnancy is a sex-based classification. ID at 496. Endpoint
Okay,
20.
this
In the
guy,
absence of a
honestly,
showing that the
Justice
pregnancy
Alito's
classification at issue was being used as a mere
concurrence
pretext,
here
T,
is actually
designed to
more
affect
clear
and
than
invidious discrimination
the
against
Chief
members of one
Justice's
sex or the
summary
other.
from the
We were
beginning. This
unwilling
is
to
more
conclude that it was
obvious,
a proxy for a sex
like
classification.
what their reasoning is
ID
legally.
at 496,
I
497,
should really
and 20.
Geduldig versus Aiello. I
We
really
applied
need
a
to like
similar principle
memorize
in Personnel
that.
Administrator of Massachusetts v. FEMA, 442 U.S. 256, 1979. There, we considered a Massachusetts policy that conferred an absolute advantage on veterans who applied for state civil service positions. ID at 264. At the time of the lawsuit, over 98% of the veterans in Massachusetts were male, and we acknowledged that the impact of the Veterans Preference Law upon the public employment opportunities of women has thus been severe. ID at 270 to 271. Even so, such severe, disparate impact did not make the law a sex classification. The distinction made by the law was, quite simply, between veterans and non-veterans, not between men and women. ID at 275. And such a classification was not a sex classification unless it could be shown that a gender-based discriminatory purpose has, at least in some measure, shaped the Massachusetts veterans preference legislation. ID at 276. The upshot of all these prior equal protection cases is that we will generally not find that a law classifies on the basis of sex unless it does so overtly, but that a challenger may escape this general rule by showing that a purportedly sex. Opinion of Alito, J. Neutral classification has been used as a mere pretext, T, designed to effect an invidious discrimination against the members of one sex or the other. Geduldig, 417
Yeah, but it's very obvious that this is
at
invidious
496
against a
to
gender, not a
497,
sex.
and 20.2.
And so legally, they
Two, when
can't
these
say in the
principles are
14th
applied to
Amendment that
Tennessee's SB1, it is clear that the law is not a sex classification.
the 14th Amendment
As the court
can't
notes,
apply
SB1
here.
classifies based on the purpose for which a minor
I
seeks
think
the
it's
covered
still
medical
pretty
treatments.
damn obvious that this is
Specifically,
discrimination,
it restricts
though.
those treatments if they are sought either for the purpose of enabling a minor to identify with or live as a purported identity inconsistent with the minor's sex, or for the purpose of reading purported discomfort or distress from a discordance between the minor's sex and asserted identity. Tennessee Code and Section 6833-103A, 1A, A, 1B, 2023. This scheme certainly refers to sex and may be seen as indirectly related to sex, but it is clearly not the sort of discrimination between males and females that our cases have treated as sex discrimination. It does not lay down one rule for males and another for females. Instead, it classifies based on something quite different, a minor's reason. 2. Contrary to the suggestion of Justice Sotomayor, this approach is fully consistent with our decision in Loving v. Virginia, 388 U.S. 1, 1967. See post at 16 N. 10, dissenting opinion. In Loving, the court confronted a Virginia law that was plainly a mea sur, designed to maintain white supremacy, and that could be justified by no legitimate overriding purpose independent of invidious racial discrimination. 388. U.S. at 11. The court correctly concluded that such a law was a race classification, and that it rested solely upon distinctions drawn according to race. Ibid. It made no difference whether the law had
I feel like
equal
I've tried to
application
do this
between
many
the races
times and
because
I
the
never
Equal Protection
can.
Clause requires the consideration of whether the classifications drawn by any statute constitute an arbitrary and invidious discrimination. ID at 10. As I have explained, the same is true regarding sex classifications. When a law employs any classification for the purpose of invidious sex discrimination, that classification is rightly treated as a sex classification.
Nope, I fuck that up every time I do it. I pretty much never do that correctly.
Syllabus. Note, where it is feasible, a
Nope.
syllabus.
It just took me back to the top again. I am
sick
sick of it doing that. I don't know. We were probably on page 69 or something. 54.
Neutral classification has been used as a mere pretext, signed to effect an invidious discrimination against the members of one sex or the other. Geduldig, 417 U.S., at 496 to 497, n. 20.
Okay, why does it stop reading? Why? Somebody explain this bullshit. No, I probably could have made that if I tried. Oops. Stop. Why is the reading so bad right now? Again, this is probably why I should go back to Microsoft Word instead of this.
When these principles are applied to Tennessee's SB1, it is clear that the law is not a sex classification. As the court notes, SB1 classifies based on the purpose for which a minor seeks the covered medical treatments. Specifically, it reads.
Oh my god, why is it sucking at reading right now?
Restricts those treatments if they are sought either for the purpose of
It's
enabling
not,
a minor
it's
to
not because
identify
my
with, or
mouse
live
is
as,
over
a
there,
reported
right?
identity inconsistent with the minor's sex, or for the purpose of reading purported discomfort or distress from a discordance between the minor's sex and asserted identity. Tennessee Code and Section 6833-103A, 1A, A, 1B, 2023. This scheme certainly refers to sex and may be seen as indirectly related to sex, but it is clearly not the sort of discrimination between males and females that our cases have treated as sex discrimination. It does not lay down one rule for males and another for females. Instead, it classifies based on something quite different, a minor's reason. 2. Contrary to the suggestion of Justice Sotomayor, this approach is fully consistent with our decision in Loving v. Virginia, 388 U.S. 1, 1967. See post, at 16, n. 10, dissenting opinion.
Okay, I got
In
one.
Loving, the court confronted a Virginia law that was plainly designed to maintain white supremacy, and that could be justified by no
There's
legitimate
5?
overriding purpose independent of invidious racial discrimination. 388. U.S. at 11. The court correctly concluded that such a law was a race classification, and that it rested solely upon distinctions drawn according to race. It made no difference whether the law had equal application between the races because the Equal Protection Clause requires the consideration of whether the classifications drawn by any statute constitute an arbitrary and invidious discrimination. ID at 10. As I have explained, the same is true regarding sex classifications.
Oh, what?
When a law employs any classification for the purpose of invidious sex discrimination, that classification is rightly treated as a sex classification.
So we're facing something kind of complicated here. They're kind of quickly having to decide whether or not
Note, where it is feasible,
gender and sex are similar, and whether or not being trans is like a sex.
The syllabus
Stop doing this document. You have to stop doing this. I am trying to play a game and read at the same time, and you're not helping. I have to figure out why it keeps dying, or if I'm just going to have to bring this into Microsoft Word.
Head note will be released, as is being done in connection with this case, at the time the opinion is issued. The syllabus constitutes no part of the opinion of the court but has been prepared by the reporter of decisions for the convenience of the reader. See United States v. Detroit Timber and Lumber Company, 200 U.S. 321, 337. Supreme Court of the United States. Syllabus. United States v. SKRMETTI, Attorney General and Reporter for Tennessee, ETAL. Certiorari to the United States Court of Appeals for the Sixth Circuit. Number 23 to 477. Argued December 4, 2024, decided June 18, 2025. In 2023, Tennessee joined the growing number of states restricting sex transition treatments for minors by enacting the prohibition on medical procedures performed on minors related to sexual identity, Senate Bill 1, SB 1. SB 1 prohibits healthcare providers from prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of 1. Enabling the minor to identify with, or live as, a purported identity inconsistent with the minor's biological sex, or 2. Treating purported discomfort or distress from a discordance between the minor's biological sex and asserted identity. At the same time, SB 1 permits a healthcare provider to administer puberty blockers or hormones to treat a minor's congenital defect, precocious puberty, disease, or physical injury. 3 transgender minors, their parents, and a doctor challenged SB 1 under the Equal Protection Clause of the 14th Amendment. The district court partially enjoined SB 1, finding that transgender individuals constitute a quasi-suspect class, that SB 1 discriminates on the basis of sex and transgender status,
Sick.
and that SB 1 was unlikely to
So I
survive
just need
intermediate
to
scrutiny.
get the other one
The
to pop
Sixth Circuit
in.
reversed, holding that the law did not trigger heightened scrutiny and satisfied rational basis review. This court granted certiorari to decide whether SB 1 violates the Equal Protection Clause. Held, Tennessee's law prohibiting certain medical treatments for transgender minors is not
Oh my
subject to heightened
God.
scrutiny under the Equal Protection Clause.
I think
of
I'm
the
gonna have to
14th
download
Amendment
this and put it
satisfies
into
rational-
Microsoft Word because it's just gonna keep taking me to the wrong place. Yep. Okay, I'm about to open this in Word. Man, I don't know. After like a certain number of pages, Word almost always becomes the better option. And I essentially kind of have to use Word at some point. It's just so annoying. I literally just cannot get away with just reading it normally. 35,000 pages. Jesus. 35,000. Sorry, words. 35,000 words. All right. Let's get to whatever page we're trying to get to. 1735. It has not loaded all the pages yet. Word is now crashing. Classic, classic, classic. Oh, right, it's going to do this sort of thing. So I need to manually find Alito's opinion and start there. Here we go. I am now Alito's opinion. I need to scroll a little bit until I find where we were before. Good old gig. Okay. Wow, well, it made the text look way more dense suddenly. There's always some kind of bullshit that has to happen. Here we go. Got Microsoft Word pulled up. Now I'm going to have to put a stupid filter on this. So it cuts off the dumb stuff. Crop. Crop. Top. Let's go with a mint 100. Oh, it's going to have to be way more. 200. 250. Bottom. I don't know. 100. 75. 60. 50. Wow. 40. 30. 40 it is. Okay, now I got that pulled up. Impossible. All of this is simply impossible. Alright, read aloud. Thank you, Microsoft Word. You always have my back. in my
This
greatest times
classification
of
scheme
need.
is also not a mere pretext. T.
God,
Designed to
but I
effect
hate
an
this
invidious
voice.
discrimination against the members of one sex or the other.
Okay.
Geduldig,
Back to reading.
417 U.S. at 496 to 497 and 20. The law begins with a panoply of legislative findings that make clear that the legislature's purpose was to protect the health and welfare of minors. Section 68 of 33-101A. The legislature concluded that the prohibited medical procedures were experimental in nature and not supported by high-quality, long-term medical studies, and that often a minor's discordance can be resolved by less invasive approaches that are likely to result in better outcomes. Section 68 of 33-101B, C. These findings are consistent with those made by other respected bodies that cannot be charged with hostility to minors experiencing gender dysphoria or to transgender people in general. See ante at 3 to 4. And the limited scope of SB 1 strongly supports the conclusion that the legislature's true purpose
I see
was
their
exactly
position.
the one set out in the statutory findings.
They think they're protecting
SB1
minors.
targets only
Oh,
the
this is so
experimental
interesting.
medical procedure.
So this connects in a really roundabout and complicated way to another kind of recent discussion. But this is out of where I live personally. This is kind of a local thing. So there was this guy, I forget his freaking, I think his name is Mike Lindell. He's a business owner here in America, and he's the owner of the My Pillow company. I don't know, it's like a bamboo-filled pillow or some shit. I don't know much about it. But he's the owner of this company, and he supported Trump's conspiracy theory that the election was stolen in 2020, I believe. So he was an election denier. But this guy was different. He dedicated his life to an election denialism, like hard. He put in fucking work to deny any concept that, you know, that Trump actually lost. He drank the fuck out of the Kool-Aid, and right now he's starting to finally face trials for all of his bullshit. And the discussion is whether or not if someone like this truly believed, if someone like this truly intently believed that the election was stolen and they were acting in right of mind in accordance with what they believed objective reality to be, the question then concerns is to what degree can you hold a person accountable for doing something that they thought was innocuous, and it was genuinely their belief that, you know, what they were doing was all right. Can you hold such a person accountable, right? And so this guy's arguing, he's like, to the best of their knowledge, what they are doing is right and moral. They are protecting minors. They think that this is efficacious, and we don't see any sign of malicious intent to cause harm. And you know what? I would say that according to like the Christian rhetoric, I would mostly concur. I would say most of these people, I mean, obviously these lawmakers are just occupied with the culture war. That's the truth and the reality of the situation. They need to generate an enemy in the form of trans people and you know, all this stuff to sort of bolster their Christian base into believing that like they're, you know, Christians are obsessed with this self-victimization complex, even though Christians have constantly had way too much power throughout human history. No, I think there are a lot of Christians who genuinely think that like being trans is a woke mind virus, and it you know, it's gonna make their children mutilate their bodies for fun, not because they like have gender dysphoria. No, that's not a thing. That's not real. Everyone knows that. Yeah. No, stop. Come on, Link. Do it. Yeah, so I actually can see the legal reasoning for, oh, you know, this isn't malicious. Like, obviously, if you were a trans person and you were, a 17-year-old trans kid, you would see this as malicious because it looks malicious. Because it is. But to, like, a bystander, if you sat down and listened to the rhetoric of the bill writers and how they're like, oh, there's so many people that regret it, and, like, it's just, genital mutilation and, like, all this other shit, while they give their children's circumcisions. Yeah, I do actually think I see their reasoning. Not that I agree with it or I actually believe it is based in empathy, but I see their logic itself, unfortunately.
That the legislature found to be unsupported and dangerous. It does not regulate any other behavior in which minors might engage for the purpose of expressing their gender identity. It says nothing at all about names, pronouns, hairstyles, attire, recreational activities or hobbies, or career interests. And the law's restrictions apply only to the treatment available to minors. Once individuals reach the age at which they are able to make informed decisions about medical care, the law imposes no restrictions. 3. In an effort to show that SB 1 classifies based on sex, the plaintiffs, the dissent, and some of the plaintiffs' amici rely on what they understand to be the court's reasoning in Bostock, 590 U.S. 644. See brief for respondents in support of petitioner 24-32, post, at 14-15, Sotomayor, J. dissenting, brief for State of California et al. As amici curiae 14-16, brief for Kentucky plaintiffs et al. As amici curiae 10-16. This argument is misguided. The decision in Bostock was based on the conclusion that the specific language employed in Title VII of the Civil Rights Act of 1964 prohibits an adverse employment action if sex is a but-for cause of that action. 590 U.S. at 656-660. And in fleshing out what this means, the court engaged in a controversial form of counterfactual reasoning. I dissented in Bostock, but I accept the decision as a precedent that is entitled to the staunch protection we give statutory interpretation decisions. See Kimball versus Marvel Entertainment, LLC, 576 U.S. 446.
I am not winning right now. This is
2015.
It is not happening for me right now.
Union, 491 U.S. 164, 172
How the hell
to
am I getting up there?
173, 1989. But there is no reason to apply Bostock's methodology here. The Equal Protection Clause does not contain the same wording as Title VII, and our cases have never held that Bostock's methodology applies in cases in which a law is challenged as an unconstitutional sex classification. On the contrary, as I have explained, our cases have adopted an entirely different methodology. I would follow those precedents. 2.
Well, I need that bow. That was a good bow. I like the Phrenic bow. Oh, I can just drop the soldier's bow. 2? Thank you. You said the number 2. I really appreciate it.
My main point of disagreement with the court concerns its analysis of the plaintiff's argument that SB 1 unconstitutionally discriminates on the basis of transgender status.
Fuck with their argument
See
harder.
brief for respondents in support of petitioner 37-38.
He wants to fight the argument.
The court holds that the law does not classify on this ground, and the court therefore applies rational basis review. Ante, at 16-18. I am uneasy with that analysis and would reject the plaintiff's argument for a different reason, because neither transgender status nor gender identity should be treated as a suspect or quasi-suspect class.
Oh my God,
I will not
it is
dwell on the
struggling to
question
read.
whether SB 1 classifies on the basis of transgender status or gender identity because, in the end, I do not think that the answer to that question has any effect on the outcome of this case. But the argument that SB 1 classifies on those grounds cannot easily be dismissed. As noted, the law prohibits medical procedures that are intended either to enable a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to reat purported discomfort or distress from a discordance between the minor's sex and asserted identity. Tennessee Code in a section 68-33 103 A1 A1B. Therefore, the underlying basis for the classification is a minor's intent to express a gender identity different from the minor's biological sex. If being transgender is defined as have, ing, a gender identity that differs from sex, see brief for respondents in support of petitioner 4, then the intent to identify with, or live as, a purported identity inconsistent with one's sex would appear to be the natural result or consequence of being transgender. The court nonetheless concludes that SB1 does not classify based on transgender status, and in doing so, it relies chiefly on our decision in Geduldig, for 17 U.S. 484. Ante, at 16-17. The dissent responds by denigrating Geduldig and contending that the decision should be discarded.
Interesting.
Post, at 23-24, opinion of Sotomayor, J. I would not enter into this debate about SB1's classification scheme. I would assume for the sake of argument that SB1 classifies on the basis of transgender status and move on to the question whether such a classification is either suspect or quasi-suspect and thus warrants some form of heightened scrutiny. That important question has divided the Courts of Appeals 5, and if we do not confront it now, we will almost certainly be required to do so very soon. B. In my view, transgender status does not qualify under our precedents as a suspect or quasi-suspect class. We have never set out a hard and fast test that can be used to identify such classes, but, as I explain in more detail below, our decisions have identified certain key factors that transgender individuals do not share with members of suspect and quasi-suspect classes.
What the fuck?
Transgender status is not immutable, and as a result, persons can and do move into and out of the class. Members of the class differ widely among themselves, and it is often difficult for others to determine whether a person is a member of the class. And transgender individuals have not been subjected to a history of discrimination that is comparable to past discrimination against the groups we have classified as suspect or quasi-suspect.
Oh my god, I instantly fell. I'm an idiot. What am I doing?
5. Compare Grimm versus Gloucester CTY. School BD 972F 3D 586 610 CA 4 2020 T. Transgender people constitute at least a quasi-suspect class. Hecox versus Little 104F 4th 1061 1079 CA 9 2024 G. Gender identity is at least a quasi-suspect class. Quoting Karnowski versus Trump 926F 3D 1180 1200 to 1201 CA 9 2019 with LW v SKRMETTI 83F 4th 460 486 CA 6 2023 and either the Supreme Court nor this court has recognized transgender
I literally
status
never
as a
get
suspect
that.
class. Adams versus School BD of St. John's CTY 57F 4th 791 803 N5 CA 11 2022 NBank W. E. of grave doubt that transgender persons constitute a quasi-suspect class. 1. In order to understand why transgender status should not be treated as either a suspect or quasi-suspect class, it is helpful to recall the path that led the court to identify those groups and afford their members heightened protection. As the court notes, ante, at 8, laws routinely confer benefits or impose burdens on particular classes of individuals, and we have long held that equal protection principles permit such classifications so long as they be some fair relationship to a legitimate public purpose. Plyler v. Doe, 457 U.S. 202, 216, 1982. We first developed that standard during the New Deal era, when the court was frequently called upon to decide whether economic legislation was consistent with the Constitution. In response to those challenges, the court adopted the principle that regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless it is of such a character as to preclude the assumption that it rests upon some rational basis within the knowledge and experience of the legislators. United States versus Caroline Products Company, 304 U.S. 144, 152, 1938. At the same time that the court developed this rational basis standard, however, it suggested that some laws should be afforded a narrower presumption of constitutionality and should therefore receive more exacting judicial scrutiny. Ibid. N. 4. The court opined that a different standard of review might apply to legislation directed at particular religious, or national, or racial minorities.
And how the hell exactly do I get up there?
153, N4, citations omitted. It reasoned that a more searching judicial inquiry might be required for such legislation because prejudice against discrete and insular minorities may be a special condition, which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities. Ibid. Consistent with that discussion, the court soon held that, classifications based solely upon race must be scrutinized with particular care, since they are contrary to our traditions and hence constitutionally suspect. Balling vs. Sharp, 347 U.S. 497, 499,
Still really don't know how to get up there.
Such classifications, the court later noted, must be viewed in light of the historical fact that the central purpose of the 14th Amendment was to eliminate racial discrimination emanating from official sources in the states. McLaughlin v. Florida, 379 U.S. 184, 192, 1964. The discrimination that the court had chiefly in mind was discrimination against blacks, who undoubtedly constituted a discrete and insular minority, that was denied equal participation in the political process. Caroline Products, 304 U.S., at 153, N4. As our cases from the period plainly illustrate, blacks faced widespread discrimination not only in fact but also in law. State and local authorities enforced a regime of official segregation in transportation. See Plessy v. Ferguson, 163 U.S. 537, 540, 1896. Schools. See Brown v. Board of Education, 347 U.S. 483.
At least I know 3 of these.
To 488,
Might not know all of them, but I know several of these.
And all manner of public accommodations. See Watson v. Memphis, 373 U.S. 526, 528, 1963, concerning the segregation of municipal parks and other city-owned or operated recreational facilities. Blacks were also widely impeded from participation in the political process. For example, several states enacted literacy tests for voter registration that were designed to prevent African Americans from voting. Shelby County v. Holder, 570 U.S. 529, 536, 2013, citing South Carolina v. Katzenbach, 383 U.S. 301, 310, 1966. States also devised methods for excluding or impeding black citizens from serving in public office.
Ooh, I guess I should check the audio to see if there's been any problems.
273 U.S. 536, 541, 1927, holding unconstitutional a law that excluded black citizens from TAC, part in a primary election. Anderson v. Martin, 375 U.S. 399, 400. For elective office.
Audio sounds fine.
Given this history of pervasive discrimination and the fact that the central purpose of the 14th Amendment was to eliminate racial discrimination, the court concluded that racial classifications are constitutionally suspect.
We can't use the 14th Amendment to improve people's lives.
McLaughlin, 379 U.S. at 192,
because
citation and internal quotation
that
marks
was only
omitted.
For racism.
And at around the same time, the court also treated national origin and ancestry as suspect classes, largely because of their proximal relationship to race. See, e.g., Woaw A versus California, 332 U.S. 633, 646, 1948. Korematsu
okay, well the
versus
solution
United
has
States,
to be me getting in there somehow.
US 214, 216, 1944, overruled by Trump versus
I think
Hawaii,
that much is obvious.
585 US 677, 2018. Point 7. The court
I wonder
has
if there's a
also
way to
suggested
just
that
tank
religion is a
that
suspect
blight
class.
and get in.
See Caroline Products, 304 U.S. at 152.
This is how much I refuse to think. I'd rather
that
just
determination follows from the
do
First
some fuck
Amendment,
shit
which
to get
prohibits
in.
any impairment of the free exercise of religion. But because this right is expressly protected
Is
by
that
that
high enough?
provision,
Oh, I could
questions
totally
of
just
religious
fly.
discrimination have generally been decided on First Amendment grounds.
Yeah, I totally could have just done that a while ago. I'm just
Philadelphia,
stupid.
593
Oops.
U.S. 522, 532, 2021, Espinoza v.
Okay, I don't actually think that did anything for me though, unfortunately. So that's pretty annoying. Isn't this like a hole?
7. The court has also sometimes referred to alienage as a suspect class. See Nyquist versus Mocklet, 432 U.S. 1, 7, 1977.
Where am I? I'm over the top right now.
Alienage, however, is quite unlike the other suspect classes the court has identified. Our cases make clear that constitutional scrutiny only applies to state, not federal, laws that classify based on alienage.
How the hell
See examining
do I
BD
get
of
up there?
engineers, architects, and surveyors versus Flores de Otero, 426 U.S. 572, 602, 1976. And it applies to only those
Am I
state
totally
laws
tripping
that
or what?
discriminate
Like, how do we get
against
up there? I don't
aliens who
remember
are
anymore.
lawfully admitted.
I totally should have been done with this
Ibid,
by now,
see
but I
also
don't have
Fowler
this
versus
memorized.
Doe,
I just do not.
457 U.S. 202, 219, and 19, 1982. We reject the claim that illegal aliens are at suspect class. The court applies such scrutiny not because state laws classifying based on alienage are inherently problematic, but rather because the federal government has primary responsibility in the field of immigration and naturalization. Flores de Otero, 426 U.S., at 602. The identification of alienage as a suspect class is therefore less a result of historical discrimination based on immutable characteristics and more a result of the Supremacy Clause.
All right, well, with that in mind, I guess the only option is
Takahashi
to
versus
fucking...
Fish and Game comment,
I don't even know.
334 U.S. 410,
I don't remember how to get up there. I never feel like I never do.
417, 1948. Truex versus Reich, 239 U.S. 33, 41 to 42, 1915. Montana Department of Revenue, 591 U.S. 464, 473 to 474.
Oh, it looks like it's that.
2020. Masterpiece Cake Shop, Limited v. Colorado Civil Rights Comment, 584 U.S. 617, 638, 2018.
Maybe I finally found my chance to get in.
With this history in
somehow.
mind, it is apparent that the circumstances that led to the identification of race and national origin as suspect classes were truly extraordinary. As the court subsequently explained, the designation of a suspect class is reserved for those classes saddled with such disabilities, or subjected to such a history of purposeful unequal treatment, or relegated to such a position of
that took a
political
long
powerlessness
fucking
as to
time 'cause I
command
am
extraordinary
dumb.
protection from the majoritarian political process.
What is
San
going on
Antonio
here?
Independent School
I see it.
DISTV Rodriguez, 411 U.S. 1, 28, 1973. An entitlement to suspect class status
I am
is
an
largely
engineer.
reserved for those groups whose members
Everyone
tend
knows
to carry
that.
an obvious badge of their membership in the suspect class, which in part
I am
explains the
definitely a
severity or
huge-brained
pervasiveness of the
engineer.
historic legal and political discrimination against the group.
Hi, how the hell did that help me?
Matthews versus Lucas, 427
What exactly did that just do
U.S.,
for me?
495, 506, 1976.
What?
Suspect class status is therefore generally inappropriate for large, diverse, and amorphous groups, Rodriguez, for 11 U.S., at 28, that do not share
Watch this,
obvious,
I'm gonna do some
immutable, or
bad
distinguishing
shit for
characteristics
no
that
reason.
define them as a discrete group, Ling versus Castillo, 477 U.S., 635, 638, 1986. See also Matthews, 427 U.S., at 506,
Sick.
Cleburne versus Cleburne Living Center Incorporated.
I'm sure that wasn't
473
necessary, I
US,
just chose to do it.
432, 442 to 443, 445, 1985.
What? Perish.
No one can doubt that race satisfies all these criteria. Racial minorities experienced a
Wow,
long
why do I
history
not
of
remember this part of the
invidious
puzzle at
discrimination
all?
and
I
lack
could
of
swear the last time I
political
played,
power.
I just did some shit that you're not
Race,
supposed to
as that
get in.
concept was long understood in this society, is an immutable characteristic that often coincides with a visible and distinguishable badge of membership in the group. Matthews, 427 U.S., at 506. And both our Constitution and our traditions provide that discrimination based on race is prescribed in all but the narrowest circumstances. Balling, 347 U.S., at 499.
Did they just say fucking balling?
We have therefore viewed, and continue to view, racial classifications as
Whoa, what just
inherently
happened?
suspect. Students for Fair Admissions
Stop this.
Incorporated via President and Fellows of Harvard College, 600 U.S., 181, 209, 2023, internal quotation marks omitted. And since Brown versus Board of Education, 347 U.S. 483, we have struck down nearly every race or national origin-based classification that has come before us. Our now overruled affirmative action decisions were the exception to the rule. Students for Fair Admissions, 600 U.S., at 211 to 214, 224 to 225, overruling Regents of University of Cal via Bakke, 438 U.S., 265, 1978, and Grutter versus Bollinger, 539 U.S., 306, 2003. See also 600 U.S., at 287, Thomas, J. Concurring, the court's opinion rightly makes
What
clear
did
that
that do for
Grutter
me?
is,
That didn't really
for
do
all
anything.
intents and purposes, overruled. 2. This court has never equated classifications based on sex with classifications based on race or national origin for equal protection clause purposes. VMI
Under the
518
14th. So they're
US
just saying the 14th Amendment doesn't give a shit about trans people.
Sex-based classifications are suspect. But since the 1970s,
Let's
the
vote
court
on the
has
new amendment,
recognized that
then.
such classifications
When's the last
warrant
time
more
the US
careful
ever actually tried to
inspection
do
than is
anything with
provided
the
by ordinary
Constitution?
rational basis review. See Ibid, Craig, 429 U.S. at 198.
Yeah, I didn't think so.
We often refer to this as heightened scrutiny, or intermediate scrutiny, and we have used the term quasi-suspect to describe groups that qualify for this form of heightened review. See
All right, I'm gonna
e.g.
go get my
Cleburne,
shit rocked by
473
Thunderblight
U.S.
Gannon
at
for no reason.
442. Under heightened or intermediate scrutiny,
Man, I wanna make
it
me
must
a
be
meal.
shown
I'm
that
hungry.
a sex-based classification serves important governmental objectives and that the discriminatory means employed are substantially
your
related
body
to the
parts.
achievement
Thank
of
you.
those objectives. Morales Santana, 582 U.S. at 59.
That's a
internal
hard shot to
quotation
hit.
marks omitted. This heightened scrutiny
All right,
standard
what
was
exactly
developed
did all
in
those do for
recognition
me?
of the
And
fact
what am I
that
supposed to do?
classifications based on sex share many features with classifications based on race. Early on, the lead opinion in Frontiero
I really
versus
don't quite
Richardson
follow
observed
here.
that our nation has had a long and unfortunate history of sex discrimination that resulted in statute books laden with gross, stereotyped distinctions between the sexes.
Huh.
411 U.S. at 684
I guess I'm trapped in
to
here forever now.
685. Although the opinion acknowledged that the position of women in America
There's two?
improved markedly, it noted that women still face pervasive,
Whoa!
although at times more subtle, discrimination.
Whoa!
ID at
Got murdered.
685 to 686.
I need to stop not
That
paying
pervasive
attention.
discrimination against women could be explained in part because of the high visibility of the sex characteristic.
Man, do I have to get the fuck back there
ID
manually?
At 686.
Holy shit,
And
I
such
probably
sex
do.
discrimination was
And I don't know if
particularly
the
unfair.
Thunderblight
The
things are
opinion reasoned
gone.
because sex,
I
like
think they
race
are
and
good.
national origin,
That still
is
suck,
an
though.
immutable characteristic determined solely by the accident of birth. Ibid. On these bases, the Frontiero plurality opined that classifications based on sex should be treated as inherently suspect, just like classifications based on race. ID at 688. Although the full court never adopted that position, it has justified the imposition of heightened scrutiny on largely the same grounds. As the court later noted in Craig, a whole range of laws still on the books reflected archaic and overbroad generalizations and increasingly outdated misconceptions concerning
Holy
the role
hell,
of females.
okay.
For 29 U.S., at 198 to 199, internal quotation marks omitted. The court has further observed that women, like blacks and other racial minorities, tend to carry an obvious badge of their membership in the disadvantaged class, and the court saw this as a partial explanation for the severity or pervasiveness of the discrimination experienced by both groups. Matthews, 427 U.S., at 506. And women, like blacks, had long been excluded, either by law or prejudice,
Man, why does him
from
saying
equal
blacks like that
participation in
sound
the
wrong?
political process. CVMI, 518 U.S., at 531. Thus, the application of heightened scrutiny to sex classifications can be explained in large part by the fact that sex discrimination shares many characteristics with racial discrimination. It was historically entrenched and pervasive. It was based on identifiable and immutable characteristics, and it included barriers to full participation in the political
So the
process.
issue is that these people don't believe in
Despite
trans
all
people
this,
existing, so
however,
they can't
the court has not
identify them
perfectly equated these
as
two
trans,
forms of discrimination.
whereas the 14th Amendment has
CID at
involves
532.
identifiable characteristics.
We have
So they're
acknowledged
saying,
that the
well,
physical
we're too ignorant to
differences
understand
between
what
men
trans
and women
people are,
enduring and
so
remain
it's
cause
just
for
not real enough. We
celebration.
don't care.
ID at 533. For this reason, sex is not a categorically prescribed classification. Ibid. Principles of equal protection do not require legislators to ignore reality that there are real differences between men and women that may sometimes justify legislation that classifies based on sex. Win, 533 U.S. at 66. And classifications based on sex have occasionally been upheld. See, E.D. Michael M. V. Superior Court, Sonoma City, 450 U.S.
Cannot believe I died,
464,
like an idiot fighting those
475
things.
to 476,
I don't even know if I have enough food to
1981,
beat
plurality
Thunderblight.
opinion, Win, 533 U.S. at 73.
Well, I actually really don't think I do, but
Three.
we'll see. I guess I could just get off my ass and put on some armor. Oh, I never bought the
Although
knight
the court
set.
has
I just
held
have
that
basic gear still.
classifications based on
Why do I
race,
keep getting my ass
national
kicked?
origin, and sex call for a higher level of scrutiny, it has frequently
Yeah,
refused
no wonder I
to
keep
apply
getting my
such
ass kicked. I'm
scrutiny
not
to
wearing
other
any real armor.
classifications. And it has done
Oh,
so
what?
even when those classifications share some characteristics with race,
Oh, hell
national
no.
origin, and sex. A few examples are sufficient to illustrate the court's general approach. Despite the fact that poor people have often been subjected to harsh and disrespectful treatment, a class defined by poverty is too large, diverse, and amorphous to qualify as suspect or
Well,
quasi-suspect.
y'all just suck.
Rodriguez, 411 U.S., at 28.
Literally,
Although age
socioeconomic
is an
status
immutable
is like the most
characteristic,
literal
the
definition
aged
of a
have
class
not
possible.
experienced the history of purposeful unequal treatment that is needed to justify a higher level of scrutiny. Massachusetts BD of Retirement versus Murgia, 427 U.S. 307, 313, 1976, per curiam,
So, what
quoting
do I have to do
Rodriguez,
here?
411 U.S.
I
at
have to
28.
put little
Presence in this
batteries
country in
there
violation
somehow.
of the immigration laws, although sometimes associated with social stigma, cannot define membership in a protected class because that status is not an absolutely immutable characteristic and may be relevant to proper legislative goals. Plyler, 457 U.S., at 220. Family relational status is likewise not entitled to elevated scrutiny because, lose relatives have not been subjected to discrimination and do not exhibit obvious, immutable, or distinguishing characteristics that define them as a discrete group. Ling,
So I need to find like
477
little
U.S.,
orbs
at
of power
638.
somewhere.
Even in close cases, the court has been notably
Where am
reluctant
I
to
gonna
apply
find
an
orbs of
elevated
power?
level of scrutiny. This is
Oh, I can
particularly
use
striking in
that
the case
somehow, I
of
think.
persons with disabilities. In Cleburne, the court considered
Fuck.
whether it should apply
Oh, there's one.
H.
Cool.
Aiton scrutiny to laws that classify
I
based
imagine
on
each of these will
intellectual
have
disability.
a little orb that I can grab.
For 73 U.S., at 442 to 443. The court acknowledged that the intellectually disabled are immutably different and that there have been and there will continue to be instances of discrimination against them that are in fact invidious. ID, at 442, 446. Nonetheless, the court found that the state's interest in dealing with
The
and
hell does
providing
this
for
do?
these individuals is plainly a legitimate one, ID, at 442, and that lawmakers have been addressing their difficulties in a manner that belies a continuing antipathy or prejudice, ID, at 443. The court further recognized that the intellectually disabled are a large and diversified group and are not all cut from the same pattern. ID, at 442. In light of all these facts, the court was reluctant to identify a new suspect or quasi-suspect class based on the existence of immutable disabilities and some degree of prejudice from at least part of the public at large. ID, at 445.
No. Okay.
Overall, our decisions refusing to identify new suspect and quasi-suspect classes exhibit two salient features. First, the identification of a suspect or quasi-suspect class has been exceedingly rare. Such status has been denied to groups, like persons with disabilities and the aged, who were found by Congress to need special legislation to protect them from widespread discrimination.
Tell me how the
Rehabilitation
aged
Act of
count, but the young
1973,
don't.
29 U.S.C. Section 701 Seek, Americans with Disabilities Act of 1990, 42 U.S.C. Section 12101 Seek, Individuals with Disabilities Education Act, 20 U.S.C.
The IDEA.
Section 1400 Seek, Age Discrimination
citing
in
things I
Employment
also
Act of
know.
1967, 29 U.S.C. Section 621 ET Seek. Accordingly, the court's reluctance to apply a special level of scrutiny to a proposed class should not be taken as a denial of the fact that the class has suffered from harmful discrimination or a lack of political power. Second, no single characteristic is independently sufficient to qualify a proposed class as suspect or quasi-suspect. Instead, in the rare instances in which the court has identified a suspect or quasi-suspect class, it has done so based on a strong showing of multiple relevant criteria, a history of widespread and conspicuous discrimination, de facto or de jure exclusion from equal participation in the political process, and an immutable characteristic that tends to serve as an obvious badge of membership in a clearly defined and readily identifiable group. 4. With this background in mind, I do not think that transgender status is sufficiently similar to race, national origin, or sex to warrant a higher level of scrutiny. Although transgender persons have undoubtedly experienced discrimination, the plaintiffs and their many amici have not been able to show a history of widespread and conspicuous discrimination that is similar to that experienced by racial minorities or women. Instead, they provide little more than conclusory statements. See, e.g., Brief for United. States 29, brief for respondents in support of petitioner 37. But as we explained in Cleburne, heightened scrutiny cannot be justified on the ground that a proposed class has suffered from some degree of prejudice from at least part of the public at large. For 72 U.S. at 445. Rather, a higher level of scrutiny is reserved for those groups,
I'm gonna go
like
fuck
racial
up
minorities
Thunderblight.
and women,
We're at page
who have
82
suffered
of
from a long
130
history of
after it's been converted to a
discrimination that is both
PDF.
severe and pervasive. See Frantero, 411 U.S. at
So he's not-
684, plurality opinion.
he's
Oh,
not
your
ignorant
nation
to the
has
very
had a long
obvious
and
fact
unfortunate
that,
history of sex discrimination. Matthews, 427
transgender people
U.S.
are being
at
discriminated
506,
against. He's just
characterizing
saying,
the historic discrimination
but
faced by women
their
and blacks
category
as
of
severed,
person
E,
doesn't
and
fit into the
pervasive,
14th
E.
Amendment.
Furthermore,
I can't
there is
tell
no
if this one's
evidence that
transphobic. I'm
transgender
starting to think that
individuals, like
Alito's
racial
not.
minorities and women,
I'm starting to
have been
think he's not
excluded from
particularly
participation
transphobic.
in the political process.
He's
It is
saying
certainly
transgender
true
people
that the
have been
very small
excluded from.
size of the transgender
No, but they have been
population
robbed
means
of
that the
liberty
members
and the
of this
pursuit
group
of
cannot
happiness.
wield much political clout simply by casting their votes. But that is true of a variety of other groups who cannot themselves mandate the desired legislative responses. Cleburne, 473 U.S.
I have made a mistake.
at 445. And despite the small size of the transgender population, the members of this group have had notable success in convincing many lawmakers to address their problems. See brief for respondents 47,
Yeah, I mean,
citing
people
Cal
like
EDUC
wanted
code
to
in
kill
section
people over this.
221.5 F, West 2021, Virginia code in section 38.2 3449.1, 2020, Washington Reverend
All right. I guess I'll listen while fighting Thunderblight. I just don't think that's going to go well.
080, 2024, see also Cleburne, 473 U.S. at 443, arguing that the distinctive legislative response to the problems of the intellectually disabled belies a continuing antipathy or prejudice and a corresponding need for more
fight.
intrusive oversight by
If
the
I remember, it
judiciary.
is consistently this fight that's the
The parties
hardest.
in this case also admit that transgender status is not an immutable characteristic. CTR of Oral Arg 97 to 98. Instead, a person's gender identity may shift. T, and a
It
person
says
who is
read.
transgender
No, I just
now
hate
may
this
not
fight.
be
This is hard as
transgender
fuck.
later. ID at 98. See also brief for Society for Evidence-Based Gender Medicine is Amicus Curiae 19 to 25, discussing the rates of desistance among transgender youth. Moreover, transgender status, unlike race and sex,
I'm gonna
is
have to
often
fuck him
not
up.
accompanied by visibly identifiable
The only option is to
characteristics.
fuck him up.
A person's gender identity is an internal sense, Merriam-Webster's Collegiate Dictionary, at 520, and transgender
When I
persons
actually
as a
play
class
this game,
do not
I almost
uniformly
never,
exhibit obvious, immutable, or distinguishing characteristics that define them as a discrete group. Ling,
Oh my god, I died
477
instantly.
U.
Holy
S
shit.
at
I do not have enough
638.
health for this fight.
Nor do they necessarily
Holy
tend
hell.
to carry an obvious badge of
I'm
their
gonna have to
membership
lock
in
the
the
fuck
class
in.
that
I don't
might
want
serve
to.
to exacerbate discrimination. Matthews, 427
What?
U.S. at 506.
No way.
Finally,
I'm gonna
the
have to fight it
definition
like
of
10
transgender
times.
status that we have been given reveals that transgender people make up a diverse and amorphous class. Rodriguez, 411 U.S. at
Okay,
28.
I'm just restarting the fight then.
Individuals are regarded as transgender whenever they have a gender identity that differs from the sex they were assigned at birth. Brief for
Whoa, that
respondents in
hurt.
support of Petitioner 4.
Yeah, I'm gonna have to get good at
That
dodging it.
definition encompasses not just biological men who permanently identify as women and biological women who permanently
Whoa.
identify as men, but also individuals who might identify
Yeah, I
with
do
a
not have enough
particular
health to
gender
fight
at
this
a
guy.
particular point in time, and individuals who identify permanently or temporarily with both sexes, neither sex, or some other identity. See brief for American Psychological Association et al. As Amici Curiae
Kill him.
6 and N7, describing transgender youth as an umbrella
thank
term.
God, they really
can
don't have
refer
that
to
much health.
minors who are gender diverse or non-binary. We have previously refused to
Whoa,
apply
that
a
hurt.
higher level of scrutiny to such amorphous classes for good practical reasons. See, e.g., Rodriguez, for 11 U.S., at 28, Cleburne,
gonna
473
keep flurry
U.S.,
rushing you, bro.
at 442 to 443. Since such classes are not rigidly defined, it is hard to pin down whether they share the relevant characteristics that make closer scrutiny warranted. And it is difficult for both courts and legislatures to identify the outer bounds of such groups.
Alright, that's half the fight. Now he's
In
gonna
light of
drop
all
the
the
thunder
above,
rods and I have
am
to use them to
unwilling
kill himself, I
conclude
guess.
that transgender status,
I can't remember
like
how
race,
this works, but
national
whatever.
origin, and sex,
I do
is
remember I
entitled
prefer
a higher
to be
level of
up
scrutiny
and
than
not
ordinary
down during
rational
this.
basis review. That conclusion, however, should not be taken as a denial of the discrimination that transgender people have faced.
Oh yeah, this is an
Nor
issue.
should it be taken as an evaluation of any specific legislative action concerning transgender persons. It simply means that transgender persons,
Oh, no,
like
wait, this
members
whole
of
place
other
is stuck like
disadvantaged
this right
groups,
now?
the poor, the aged, the disabled, etc., have not made the extraordinary showing that they are entitled to a higher level of constitutional scrutiny. 3. Because
have to fight
transgender
him
status
like
is not
this?
a suspect or quasi-suspect
remember this
class,
being an issue.
even
Like,
if
I can't
Tennessee's
move them during the
SB1
fight, and I'd
classifies
love
on
to.
that ground, it
It'd
must
make
be
life way
sustained so long
easier.
as it bears some fair relationship to a legitimate public purpose. Plyler, 457 U.S., at 216. As the court notes, SB1 easily satisfies that standard. Ante, at 21
What?
to 24. I
I'd do it
therefore
all, but
agree
I
with
would've
the court
expected
that
it
the
to.
judgment of the United States
There
Court
you
of
go.
Appeals for the Sixth Circuit should be affirmed.
Shit, I just have to kill him that way?
Supreme
Whoa.
Court of the United States.
My scimitar.
Number 23 to
I wonder how much like
477.
extra food I have on me right now.
United States, Petitioner
Fuck.
v. Jonathan
Oh, I knew that
SKRMETTI,
would get me.
Attorney
Damn it.
General and reporter for Tennessee, ETAL.
Whew, all right, we're pausing there because we just finished up one round. We are now going on to Justice Sotomayor with Justice Jackson, joins with Justice Kagan, joins dissenting. Okay, oh my god, I have to fight. I'm gonna have to keep doing this stupid fight. Fuck, fuck, fuck. No, I'm not running out of food, am I? Right? I retain my food each round? Yeah, okay, I'll be fine. All right, I know what to do now. I mean, I remember. I remembered before. I just am clearly not locked in nearly enough, and I simply have to lock in harder. Everyone knows that. It's the only option, is to lock in more. All right, stay away from me. Wow, okay, instantly got get. That's my issue. Yeah, I have to flurry rush it to beat it if I remember. Ah, those kill me every time. I don't know what it is. I don't know what about my resistance is like weak right now, but that kills me every time. What is going on? I just don't have the right armor. Yeah, I don't have anything high enough to really help me here with this. I think I'm going to have to just go in with over max health. Wow, I really need to like go renew and use more of my I need to do more shrines, clearly.
This thing is fast. Watch yourself.
Wow, this is annoying as hell. There we go. Wouldn't lock on for nothing for me. Perish. Oh, see, that's what happens to me. I let off lock for a second and I instantly die. Okay, that's first half done. Okay, I need to get up there and zap him not once, but I believe twice or 3 times. And then I'll be done with this. And then I can go on to the dissenting opinion, which is only about 35 pages, which shouldn't take too long, probably about, you know, an hour. Yep, I know, I'm watching the lightning. Whatever you say, mama. No, wait, what does Jake say? Whatever you want, mama? Whatever you want, mama. I will do whatever you politely ask me to. That looks like it's gonna hurt. Oh, god damn it. Give me this one. You fool. Okay, and I just need to somehow get up there without... Oh, did I get him? Alright, well, I'm just gonna do that again. I'm not moving. I'm staying up here. It was a bad idea to move last time, and I regretted it. What are you doing? Was that your attempt at hitting me? Whoa. Whoa! Man, I don't know if I can do this. Hey, have fun. Hey, Carol. I'm trying to have fun. I'm actually paused the reading right now because I'm doing a boss battle and I absolutely suck. So I will return to reading once I can beat this stupid boss. I'm not worried. I only have 35 pages. 35 pages in Microsoft Word. I think practically this is more like 20 pages if this were still a PDF, but it is not a PDF.
This thing is fast. Watch yourself.
Wow. Okay, instantly getting my shit rocked. Great. I think I figured out what needs to happen. Once I get to that second round, I need to wow, okay. I need to eat my things that give me excess health so I can tank the very hard hits that are coming. Wow, that's not good. That fucker just ate through my goddamn shield. Kill him. Okay, done with the first half. On to the second half. Now I need to start spamming the higher health effect. Yeah, skip this. I don't care. Yeah, I get it. You think you're tough. Leave me alone. I'll let him do his first little round of being stupid and annoying. And I'll let him bring his stuff here this time. And I will hit the increased health ability right now. Whoa! Don't do that. That was scary. Okay, there we go. And then, yeah, I can take this one. Maybe. Ah! I didn't grab it in time. Do not do this. Leave me alone. I can't reach him. This is dumb. I am in fact struggling. Oh my god, I hate this. This shit is just not playing nice with me at all. Now I'm out of extra health. Good, there was one. Now I think this is when he starts trying to actually come up and hit me. Yeah, that starts happening. Not good overall. So I described that. Okay, let's see if I can kill him. 4, 5, 6, 7, 8. Wow. Nope. I'm so close. Killed him. Wow! The mid-air falling off the ledge bomb arrow for the defeat was kind of fucking cool. Back to reading. Oh no, I guess I should enjoy the little scene where I get to see Riju's mom again. Good job. That was some elite work. turning the AC on. Whew. Hold on. I'm eating a cookie. Absolutely. High quality work on my part. How many health thingies did I have? Like 5? Did I have 5 or 6 hearts in this fight? No, not many. Definitely do not believe I had many. So. I always wondered if it's possible to fuck up and accidentally not take the heart container at the end of this fight. Because I think you can kind of do that in the other Zeldas too. Hi, Riju's mom. I straight up do not remember her name still. This cookie is just okay. Peek. I love this lady so much. Urbosa! What a peak fucking character.
Please accept this gift, which has come to be known as Urbosa's Fury. It will no doubt be of use to you.
You know, it's interesting. This Zelda doesn't have a magic meter. You're just given these spiritual powers.
But this is how things had to happen. No one would carry her. So please, make it clear so she understands that. Tell her
Ooh, that's pretty good voice acting. Sometimes I like to imagine Link doesn't want to be taken out. She's inferring? You know what she's inferring. We all know what she's inferring with that. Homeboy is clearly the next king of Hyrule. That shit is obvious as fuck. I am literally the king of Hyrule. Oh, right, and then we get this cutscene of it walking up the mountain or something. All right, after this, back to reading. I'll start just exploring the desert. Now I get that this is them like targeting at Ganon, but it doesn't. Oh, we met Naboris in Ocarina of Time. Nah, they really make her a good character. He did, and he does pretty consistently. Nintendo, what are you up to? What is this? Y'all are on something. Da 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 da! And I always get a heart out of it. You always get health out of these, but you don't get stamina. Alright, I have to go back to reading. I don't really imagine I'll get a cutscene with Riju. Okay, we're not doing Justice Sotomayor, Justice Jackson, Ketanji Brown Jackson, Justice Kagan, and they are dissenting in part or in full.
Justice Sotomayor, with whom Justice
we're slowing
Jackson
down. We're slowing down.
joins, and with whom Justice Kagan joins as to all but Part 5, dissenting.
It is
To give
instantly
meaning
too cold
to our
in here.
Constitution's bedrock equal protection guarantee, this court has long subjected to heightened judicial scrutiny any law that treats people differently based on sex. See United States versus Virginia, 518 U.S. 515.
Oh, I'm getting so hungry. Snacks are not enough.
1996.
All right.
If a state seeks to differentiate on that
I really
basis,
do need like
it must show
3,000
that the
calories
sex
a day, even when I'm
classification
resting, which is an
serves
issue. Oh, come
governmental
on, let me in.
objectives
I
and
am
that
literally the king of
discriminatory
Hyrule.
means employed are substantially
Come
related
on,
to
I'm
the
clearly the king of
achievement those
Hyrule.
objectives. IBID, internal quotation marks omitted.
I'm literally Link
Such
from
review,
the
known
Bible.
as intermediate scrutiny, allows courts to
have to walk
ascertain
in
whether
and
the state
frickin'
has a sound,
these
evidence-based
clothes.
reason to
Yeah,
distinguish
let me
on
in.
the basis of sex or whether it does so in reliance on impermissible stereotypes about the sexes. Today, the court considers a Tennessee law that categorically prohibits doctors from prescribing certain medications to adolescents if, and only if, they will help a patient identify with or live as a purported identity inconsistent with the minor's sex. Tennessee Code in Section 68-33. 103 A1 A 2023. In addition to discriminating against transgender adolescents, who by definition identify with an identity inconsistent with their sex, that law conditions the availability of medications on a patient's sex. Male, but not female, adolescents can receive medicines that help them look like boys, and female, but not male, adolescents can receive medicines that help them look like girls. Tennessee's law expressly
It is a cool
classifies
shield.
on the basis
It's a very
of
cool
sex
looking
and
shield every time.
transgender status, so the Constitution and settled precedent require the court to subject it to intermediate scrutiny. The majority
I
contorts
should
logic
really
and precedent to say otherwise,
go get the freaking
inexplicably
map.
declaring it must uphold Tennessee's
If I'm going to keep playing this game on stream, I should probably go get the full map for the entire game and just kind of slowly work through it. With a map, it'll make a huge difference.
Ante at 21. Thus, the majority subjects a law that plainly discriminates on the basis of sex to mere rational basis review. By retreating
Playing
from
a controller-based game
meaningful
instead of one that
judicial
uses a
review
mouse
exactly
is
where it matters
definitely
most,
feels
the court
better.
abandons transgender children and their families to political whims.
While streaming.
In sadness, I dissent. Begin with the medical
Thus, the majority subjects a law that plainly discriminates on the basis of sex to mere rational basis review. By retreating from meaningful judicial review exactly where it matters most, the court abandons transgender children and their families for political whims. Correct! Based! right? This is like a meaningfully, like, if you're just not transphobic, this is a pretty common sense position. It's like, whoa, this is clearly like the original meaning of the 14th Amendment and how it was expanded and reinforced to involve, you know, protections from discrimination across the sexes. It is very obvious that this is that. It's just that the sex this time is you know, your gender identity. Obsessing over, like, well, sex and gender, that's not... People are being discriminated against. They're being practically erased from existence with this law. Uh-oh. That was definitely a mess up. I should not have done that. Maybe Link can stand right here. Link can stand right here. Look at his ankles. His ankles are about to break. Oh my god. I am really struggling to climb this right now. No, Link, you got it. You got it. Don't even worry about it, Link. Yeah, like, this is just obvious. Like, what this is obvious. What it is doing is obvious. And the dissenting opinion is also being like, dude, this is so obvious.
In which Tennessee's law operates. See Tennessee Code in a section 68 to 33 of 101 etc. See also SB 113th General Assam, first extra. Session
Is that where it was the whole time?
2023 SB 1.
Oh, it is?
Doctors in the United States
Oh, yeah, see, I'm already there.
and
I'm already at
puberty
one.
inhibitors to treat a range of medical conditions. Often, they are administered to help minors conform to the typical appearance associated with their sex identified
Come
at
on,
birth.
Link, you can make it.
Children who start experiencing puberty at a premature age, precocious puberty, for example, have long received puberty-delaying medications
Yeah, for a long-ass
to stave
time.
off puberty until adolescence. See App 22. Adolescent boys might also receive the hormone testosterone to initiate puberty delayed beyond its typical start.
time, yeah, like, you know,
App
17,
to
18,
Pet
that's when they'll start looking into that.
266A. Without testosterone, puberty would eventually initiate naturally in most patients, but medication
Social stigma,
is
yes,
often
they're
prescribed
acknowledging.
to avoid some of the social stigma
Thank God
that
to
comes
these
from undergoing
fucking Supreme Court
puberty later than
justices, but it
one's
doesn't
peers.
matter because their opinion didn't affect the
Ibid.
ruling because Trump packed the court.
Adolescent females with delayed
Goddamn.
puberty may receive the hormone estrogen for the same reason. Ibid. After puberty begins, doctors may prescribe these same medicines to adolescents whose physical appearance does not align with what
listen,
one
like-
might expect from their sex identified at birth. An adolescent female, for example, might receive
The story
testosterone
of Ruth Bader
suppressors and
Ginsburg
hormonal birth control
is
to
probably gonna go
reduce the
down in
growth
history
of
as
unwanted
something.
hair on her face or
Because
body,
she did
sometimes
such
called male
extraordinary
pattern hair
work for
growth
such
or
a long
hirsutism.
time.
See
But if she
Ibid.
had
See
just
also
stepped
at
down.
100M medications
If she
that are
had
used to suppress
just stepped
testosterone can be used to
down.
address symptoms of polycystic
We would be in a
ovarian
different
syndrome, which
timeline.
can include unwanted facial hair and body
So
hair,
it just sucks in that
excessive
way.
sweating, and body odor. Brief for experts
I can't
on
quite recall, but I think I
gender-affirming
can- I think
care
I
is
can
Amici
teleport
Curiae
to the,
12, describing the prevalence
yeah, I can
of
travel to the beast.
hirsutism in people identified as female at birth. An adolescent male may also receive hormones to address a benign but atypical increase in breast gland tissue, known as gynecomastia.
I'm as smart as a Supreme Court justice. It's confirmed. Yeah, why would you not just mention cases of gyno and the fact that these exact treatments have been a thing forever? I cannot believe that I came upon this. I heard about gyno through like gym talk people talking about dudes that were trying to increase their pec size to kind of you know, deal with the gyno, or how like the gyno was inconvenient while they were putting on muscle. And I just knew from reading the data on gender affirming care for minors, I just knew based on the data that like it's gyno is the biggest counter argument to all of this bullshit. And then the fucking Supreme Court brings it up because I'm not stupid. I'm not a moron. Yeah, it's such an easy W
Curiae
counterexample.
12, describing the prevalence of hirsutism in people identified as female at birth. An adolescent male may also receive hormones to address a benign but atypical increase in breast gland tissue.
Yeah, I
known
guess it would
as
be hormones most of the time
gynecomastia,
as opposed to top
sometimes
surgery.
resulting from
but it could be.
below average testosterone levels. See, e.g., G. Kanakis et al., EA Clinical Practice Guidelines, Gynecomastia Evaluation and Management, 7 Andrology 778, 779 to 780, 2019. Like any medical treatment, hormones and puberty blockers come with the potential for side effects. See, e.g., Apidipet for CERT 266A, 267A, App 970 and 974, brief for United States 45 to 46. Yet patients and their parents may decide to proceed with treatment on the
so
advice
why
of a
should trans
physician,
be any
despite
different?
the accompanying medical risks. Physicians prescribe these same medications to transgender adolescents.
What happened to like
whose
the rights
gender
of parents
identity is
and your
income.
obsession with that on the right?
Cis-tent with their sex
Can I physically
identified at
climb
birth.
this? Without
Hormones and
failing?
puberty blockers help align transgender adolescents' physical appearance with their gender identity, as they do when prescribed to adolescents who want to align their appearances with their sex identified at birth.
Yes, so cis
The
kids
same
can get gender affirming
puberty
care
suppressants prescribed
with
to
the
pause
guise
the
of
onset precocious
counselors
puberty
and
can cause
doctors and
puberty for
parents and
transgender
the
adolescents,
cost and the
giving them
time involved.
to further understand
Then
their
why the
gender
fuck
identity.
Can't you just do that for trans kids? And the simple and only reasonable
Hormone
answer
therapy
is
later
that the
allows
right
transgender
wants
teens
trans
to
erasure.
initiate
They
puberty
believe that what
consistent
they're
with
going
their
through is like a
gender
mental
identity.
illness. They believe that it's
That
like a fad
typically
or a
involves
trend. They don't
testosterone
think it's a
for
reflection of the
adolescent
person.
Transgender boys who were identified as female at birth, and testosterone suppression and estrogen for adolescent transgender girls who were identified as male at birth.
I do want to remind, in the middle of
Such
reading the
treatments help
Supreme Court case,
adolescents
Trump and the right-wing
identified as
administration are
female at birth
actively
look
trying
more
to edge
masculine, and those
a
identified
hot,
as male
violent,
at
bloody
birth
war
look
with
more
Iran,
feminine.
just for
As
the
is
sake
true for most
of copying to
medical
Israel,
treatment for minors,
the state of Israel.
puberty blockers and hormones should be administered only after a
They want to attack the state of Iran to cuck to the state of Israel. They officially were like, you know, anything's an option, including nukes. So we can both things can be true. Trans people deserve rights. Also, like, we shouldn't get lost on the sauce either.
Coleman et al. Standards of
It should be
care for the
easy
health
enough
of
to say, like,
transgender
if the
and
rule
gender-diverse
is
people,
that cis kids
version
can get
8,
gender affirming care,
23
trans kids can't.
International J,
That's the
Transgender
entire
Health
conversation.
S1,
This should have been thrown out.
S58.
It should have been like, oh, we don't even have
2022.
purview on this because it's such a fucking stupid question. It has nothing to do with the government.
Transgender adolescents' access to hormones and puberty blockers,
Known as gender-affirming care.
gender-affirming care, is not a matter of mere cosmetic preference.
A question of
To
life
the
or death,
contrary,
correct. And that's
access
what
to
I
care can
often
be a
lose
question of
in
life or
context
death.
because I myself don't experience a lot of
Some
dysphoria. So
transgender
sometimes I think
adolescents suffer from
as
gender
a
dysphoria, medical
a person
condition
who isn't
characterized by
dysphoric,
clinically
I think I
significant
struggle
and
to really
persistent.
communicate to you how fucking serious this is. To the people that are experiencing serious dysphoria, especially
Distress
during the
resulting
adolescent
from
years.
incongruence between a
You know,
person's gender identity and
There's
sex
data on, like,
identified
when
at
is a
birth.
person most likely to take their own life? When is a
Apidipet
person most
for
likely to be
CERT
self-destructive? When is a
251A
person
to
most likely to
252A.
engage in
If
self-harm?
left untreated,
I
gender
think we can all
dysphoria
guess
can
what
lead to
time period
severe
of life that
anxiety,
happens to most
depression,
people.
Eating disorders, substance abuse,
Oh,
self-harm,
there you go.
and suicidality.
Yeah, they got the data.
See, e.g.
To some degree,
Coleman,
this is just a
23
matter
International
of being a
J,
teenager.
Transgender health
But
at
that doesn't mean it's
S62.
good. That doesn't mean it's all right. Even if something is common or
Suicide, in
normal or there's
particular,
data,
is
that
a
doesn't
major
necessarily
concern
mean
for
it's
parents
a
of
good thing.
transgender teenagers, as the lifetime prevalence of suicide attempts among transgender individuals may be as high as 40%.
Yes, and I refuse anyone who's like,
Apidipet for CERT
well, getting them their
264A.
gender reassigned doesn't fix it.
Tragically,
Yeah, because
studies
that
suggest
doesn't
that
fix
as
the
many as
transphobia.
one-third of transgender high school students attempt suicide in any given year.
It's probably because it's been terribly politicized and they've
When
been made a
provided in
fucking
appropriate
social
cases,
black sheep
gender-affirming
scapegoat.
medical care can meaningfully improve the health and
One
well-being
day,
of
20 years from now, 30 years from now, 40 years from now, we're going to be like,
reducing
wow,
anxiety,
the government used
depression,
trans people as
suicidal
a distraction
ideation, and, for
while
some patients, the need for more invasive
allowing
surgical
the
treatments later
rich and
in
ruling
life.
class to essentially
That is why the American
accumulate
Academy of
trillions of
Pediatrics,
dollars of wealth by
American
moving it away
Medical
from the middle class.
Association, American
And they successfully got our
Psychiatric
asses.
Association, American Psychological Association, and
And
American
by the and I
Academy
don't
of
mean the
Child
left. On the left,
Adolescent
we wanted
Psychiatry all agree that hormones
equality
and
the whole
puberty
time.
blockers are appropriate
But
and
on the
medically
right, they got your
necessary
asses.
to treat gender dysphoria when clinically indicated. ID.
All right, where should I go now in the game?
285A.
I don't really know. That's the Great Plateau, isn't it? This game is so interesting. It's not like it's technologically
3CM
incredible, but
Johns
being
et
able to
al.
see,
Transgender identity
just being
and
able to see
experiences
everything
of
in a
violence,
Zelda game is a
victimization,
thing.
substance
Like, that's pretty
use,
cool.
suicide risk, and sexual risk behaviors among high school students, 68 morbidity and mortality.
Well,
Weekly
I'm so tempted to play Tears of the
67,
Kingdom because
70,
I like how
2019.
traversal works in
B.
that game more.
Tennessee has taken a different tack. The state enacted SB 1 to categorically prohibit physicians from prescribing puberty
look.
blockers and hormone therapy for the purpose of treating gender dysphoria in minors.
Got it. Very good.
Tennessee's blanket ban applies only when hormones and puberty blockers are prescribed to enable a minor to identify with
Leave me
or live as
alone.
a
I don't wanna
purported
deal with any of
identity
this.
inconsistent with the minor's sex or to
Leave me
alleviate
alone.
discomfort or distress from a discordance between the minor's sex and asserted identity.
Where the hell do these Stolfos
Tennessee
come
Code
from
of
anyway?
Section 68 to 33 103 A1.
Man, I just wanted to get to the damn shrine. I need to go through more, a whole lot more.
To treat any other medical condition, including delayed or early
I should go get the Master
puberty
Sword.
and any other physical or chemical abnormality present in a minor that is inconsistent with the normal development of a human being of the minor's sex. Section 68 to 33 102 1. In other words, SB 1 allows physicians to help
Why am I still
align
wearing this stupid
adolescents'
outfit?
physical appearance with their
Did I
gender
fight that
identity,
fight in that outfit?
despite
No,
associated
I had
risks,
to
if
get
it is
to redo.
consistent with their sex identified at birth, but not if inconsistent. Indeed, Tennessee's stated interests in SB 1 include encouraging minors to appreciate their sex.
What
Section
did that do for
68
me?
to 33 101
I probably should have just hit it with like
C.
one of these. That did not work. I'm just stupid.
Tennessee's ban applies no matter what the minor's parents and doctors think, with no regard for the severity of the minor's mental health conditions or the extent to which treatment is medically necessary for an individual child.
How do I get over there? I'm sure I can somehow.
The stories of the plaintiffs in this case reflect the stakes of factual context relevant to the court's
if
assessment
this conserved
of whether
energy the way that it
SB1 is
should, that
substantially
really
related to
probably
the
wouldn't work.
achievement of an
Oh
important
my
government
god.
interest.
I only had to shoot it 2 or 3
See
times?
Infra at 10, describing the
What?
intermediate scrutiny standard. Indeed,
Well, I could just
even
do it
Justice
without stopping
Thomas
it?
seems to recognize that some scientific and medical evidence, at least that which is consistent with his view of the merits, is relevant to the questions
Oh,
this
they're starting to
case
throw
presents.
shade between justices. I love it.
See ante at 9, 10, 14, 15, 20, referencing the Cass review in various peer-reviewed medical journals.
So like an
That
unlimited
harsh
number of you
reality.
idiots?
Ryan Rowe, now 16, felt as early as elementary school that he was a boy.
Why is this so slow?
Apodipet for Cert 234A.
Yeah, there are lots of these stories
Before
where like
puberty, Ryan
kids
thought
kind of
there wasn't
intuitively
that much
tell
of
for a
difference
while.
between boys and girls, and that he could manage existing in the middle. Ibid.
Alright, is
As
this going to be enough to
puberty
get it over
approached,
there?
However, Ryan grew increasingly anxious about the impending changes to his body.
Fuck, how is that too
He
much?
started throwing up every morning before school. As his voice changed,
You know, I
Ryan
used to have the
contemplated
throwing
going
up
mute.
before school every day situation.
ID
But I have a
at
bad stomach,
235A.
which is likely an anxiety thing.
Eventually, after 2 years of psychotherapy and
But
extensive
it was just
consultations
different
with his
anxiety. It
parents
was
and
like
doctors,
just a bunch of other
Ryan's
social
physicians
shit.
prescribed him testosterone. Ryan began to find his voice again. He started raising his hand in class,
Hell yeah.
participating in school,
I've just
and
had to
looking
waste
at
an
himself in
unlimited
the
number
mirror.
of
Ryan attests
unlimited
that
number of arrows to do
gender-affirming
this.
healthcare saved his life. ID at 234A.
Man, and like as much as like
For
save
Ryan's
life and
parents,
shit, like
IT is
just
simply
making
not
a
an
person's
option
life
to
better
cut
should be
him
enough.
off from this care.
Like it should be
ID
obvious
at
for a parent and a
246A.
child and everyone to kind of figure this out on their
I worry about his
own.
ability to survive, Ryan's mother attests. Osing him would break me. Ibid.
The fuck does ibid mean? Can
LW2
someone tell me?
began to question her gender as early as 4th grade.
Shit.
At the
Oh wait,
time,
yeah. How do I
she
block
felt
this
like
one?
she was drowning and trapped in the wrong body, often sick at school because she did not feel comfortable using the
What
boys'
should be my
bathroom.
plan here?
ID at 223A.
I stop
At
this
age
like
13, LW and her parents sought out medical treatment. puberty blockers and estrogen, prescribed to LW after consultation with her parents and doctors.
Okay, so now I'm just
changed
stuck
her
between
life.
these while I wait for a block
We
to
have
save
a
me.
confident, happy daughter now, who is free to be herself, her mom explains.
No, not
App
the
85.
chest. No.
As a
I'll
mother,
survive.
I could not bear watching my child go through physical changes that would destroy her well-being and cause her lifelong
Oh,
pain.
fuck, do not fuck up.
ID
Link,
at 86.
Link, stop, Link. You
Echoing
have to have
similar
like a
refrain,
perfect walking
John
speed.
Doe and his family
somehow.
attest that John felt from an early age
Oh,
he was a boy.
what happened over there?
He chose a male name for himself around the age of 3.
Fuck.
As puberty approached, John grew terrified of undergoing what he saw as the wrong puberty, recognizing that some of those changes
Shit,
could
man,
be
get
permanent.
Link.
After the pet for Cert 232A.
I'm fine.
After years
What the heck?
of psychotherapy,
What the heck just happened?
he began taking puberty-delaying medication. His mother, who shed many tears during the first year of this process, acknowledges that John's gender transition has not been easy. App 95. Yet
Okay,
she
it fucked
attests
up the
that
block,
John's
so I'm just gonna have
access
to figure out a way to
medical treatment
manually
is the
pull
one
this shit
thing
off.
that gives her hope that he can have a fulfilling life. ID at 94. D.
Link. Oh my god. That is
Faced
not
with
the
choice
correct solution to
between leaving
that.
Tennessee in
Hey,
search of treatment and risking their children's lives.
whatever.
Ryan, John,
I don't know why the fuck the
LW,
blocks got
and
stuck.
their
That was
parents
stupid.
sued to enjoin SB1. The United States intervened in support. Together, they argued that SB1 unconstitutionally discriminates on the basis of sex and transgender status.
Yes, transgender status, which
After
is very
review of
clearly
the
and obviously a
factual
damn
record,
status.
The district court agreed,
Oh, but
holding
it's
that
less
the law
material,
would
it's
likely fail
physical. I don't
intermediate
care.
scrutiny because its targeted
Dude, just
ban
don't
on
let people
promoting
discriminate.
inconsistency with sex
Listen,
was not
let people
substantially
discriminate
related
privately,
to
but to
Tennessee's
let
asserted
a
interest in
state
protecting
government write
minors
some
from
shit that's
dangerous
discriminatory
medical
is a
procedures.
different universe.
LWV SKRMETTI 679
That's a
F
completely
sub
different
3D
world of fucked up.
668 710 MD Tennessee 2023. A divided panel of the Sixth Circuit reversed. All 3 judges appeared to accept the premise that the statute treat minors differently based on sex. LWV SKRMETTI 83 F 4th 460 481 2023. See also ID at 484 T. The necessity of heightened review will not be present every time that sex factors into a government decision. Yet the majority refused to apply intermediate scrutiny because it believed that the law did not
Page 102 and
necessarily
129. Wow, we are not
disadvantage
reading very
persons
quickly.
based
We're
on
going to
their
be doing this
sex.
for another 2 hours or so.
ID at 483. Because the Sixth
There you go.
Circuit never applied intermediate scrutiny to SB1. The only question this court must decide is whether the Constitution
Shit, that is
required
going
it
to kill
do
me.
So. 2.
Wow. Yeah, that did kill
The
me.
level of constitutional
I'm like, well, it's
scrutiny
gonna kill
courts
me, and then
apply
it
in
promptly
reviewing
killed
state
me.
action is enormously
Oops.
consequential.
I'm stupid.
Where a state law neither proceeds
Uh-oh.
along suspect lines nor infringes fundamental constitutional
I'm still killing all these
rights,
guys. I don't care.
Reviewing courts generally
Now I'm angry.
uphold a challenged law under the Equal Protection Clause so long as any reasonably conceivable state of facts could provide a rational basis for the classification. FCC v. Beach Communications Incorporated, 508 U.S. 307, 313, 1993.
Yeah, I'm going in there. I'm
That
here. I'm here
lenient
for
standard,
blood.
which the majority erroneously applies today, demands hardly more than a cursory glance at the state's reasons for
I
legislating.
did not get the thing back that I wanted.
This
which
court
is
has long recognized,
unfortunate.
however, that a more searching judicial review is warranted when the rights of discrete and
Oh, I
insular
forgot she would do
minorities
that for
are
me
at
now.
stake. United States versus Caroline
Does she hit that
Products
hard?
Company,
She killed all of them.
304 U.S.
There's only one level of bokoblin stronger than those guys.
153
Right?
N4,
Silver / white
1938.
bokoblin? Or is silver a thing? I don't remember.
Because such minorities
Yellow,
often face
maybe.
systemic barriers
No?
to
Is
vindicating
that only
their
a Master
interests
Quest? I
through
can't
the
remember.
political process. Courts have a
Alright, I'm taking all your
comparative advantage
shit.
over the elected branches in
You guys
safeguarding their
suck.
rights. Ibid. Such judicial scrutiny
Oh,
is
I
at
have
its
room for
apex
another
in
shield. Cool.
reviewing
I
laws
didn't know that.
classify on the basis of race and national origin.
States may not enact laws that classify on those bases unless they can pass
I don't think
through
my
the
horse is
daunting
coming.
two-step examination known in our cases as strict scrutiny.
B.
Students for Fair
This is good
Admissions
news.
Incorporated B.
My horse can finally be a
President and
B.
Fellows of Harvard College, 600
Wow,
U.S.
did you just summon those guys?
181, 206, 2023, CID at 206 to 207.
What a great
Under
sword.
that standard,
Big fan
we
of this
ask
sword.
whether the racial classification is used to further compelling governmental interests, and then whether the government's use of race is narrowly tailored, meaning necessary.
Wow, this
to
looks like
achieve
one of the
that
little
interest.
areas in Tears of the Kingdom.
For nearly half a century, the court has applied a
I'm
different
seeing the
standard,
connections
known as
with, like, the game
intermediate
design.
scrutiny, to all statutory classifications that distinguish between males and females. Nevada Department of Human Resources
Thank you
versus
for,
Hibbs, 538
dogs. I've now eaten you.
721, 728, 2003.
What's in here?
See Craig versus Boren, 429 U.S.
A metal rock.
190, 197 to 199.
What did that do for me
1976.
exactly?
States can differentiate on the basis of sex only to serve important governmental objectives and only if the sex classification is substantially related to the achievement of those objectives. Hibbs, 538 U.S. at
I guess I didn't even need to do that. I
728.
could have just moved the rock around.
The standard
Sometimes
is
I
an
forget how powerful that
intermediate
is.
one because it strikes an important balance.
Topaz.
On the
Could've
one
been
hand,
cooler.
there are
Could've been
some
cooler. Let's see what
genuine
else
physical
you might find.
differences between men and women, so not all sex-based legislation is discriminatory or constitutionally prescribed. Virginia, 518 U.S. at 533.
What did this
On
do
the
for
other
me?
hand,
All I
sex-based
found
legislation
is just a
always
random.
presents a serious risk of invidious
there anything
discrimination that
important in this
relies on
area? I'm
overbroad
confused.
generalizations about the
All that
different
for a piece of
talents,
topaz? That was stupid.
capacities, or preferences of males or females. IBID intermediate scrutiny is the core judicial tool to differentiate innocuous sex-based laws from discriminatory
Well, that certainly
ones.
seems like an interesting place.
B.
Satori Mountain. B?
SB 1
What, we can
plainly
finally be a bee?
classifies on the basis of sex, so the Constitution demands intermediate scrutiny. Recall that SB 1 prohibits the prescription of hormone therapy and puberty blockers only if done to enable a minor to identify with, or live as, a purported identity inconsistent with the minor's sex or to alleviate discomfort or distress from a
Well,
discordance
now the horses
between
ran
the
away,
minor's
dang it.
sex and asserted
No,
identity.
no, come here. I want this one. Come here.
Tennessee Code in a section 68 to
Thank you, horse.
33
I'm gonna ride you real
103
quick. Come on.
A1. Use of the same drugs
going
to
this
treat
way.
any other disease is unaffected. Section 68 to 33 103.
Yeah, it is literally banning the
B1A.
exact same drugs that are being used.
Physicians may continue,
for a different
for
patient.
example, to prescribe hormones
they're still making the
puberty
argument
blockers
that those
to treat
drugs are
any
dangerous.
Physical or chemical abnormality present in a minor that is inconsistent with the normal development of a human being of the minor's
Man,
sex.
if I were Tennessee, I would have done separate.
Section 68 to 33 102.
I would have
1.
done two separate legislations.
What
one
does
for
that mean in practice?
one for
Simply
surgery,
that
one
sex
for
determines
puberty
access
blockers, so
to
that way
covered medication.
one might survive, one might not.
Physicians in
Not that I
Tennessee
agree
can
with that, it's
prescribe
just-
hormones and
I
puberty
know it.
blockers to help a male child, but not a female child, look more like a boy, and to help a female
The
child,
horse fell
but
in
not
the
a male
water?
child, look more like a girl. Put in the statute's own terms,
How the hell did that
doctors
even
can
happen?
facilitate consistency between an adolescent's physical appearance and the normal
I've
development
never even
of
seen
her
that
sex
happen
identified
before.
at birth. But they may not use the same medications to facilitate inconsistent with sex. All this, the
What?
state openly admits, in service of encouraging minors to appreciate their sex.
Yeah, so
Section
they say.
68 to 33 101M.
Oh shit! What do I still have
Like
on me?
any other statute that turns on inconsistency with a
What
protected
did I still have on me?
characteristic,
I thought I took my
SB1
shit off.
plainly classifies on the basis of sex.
Well, maybe that horse isn't dead now.
A simple analogy
I'd feel bad.
illustrates the point. Suppose Tennessee prohibited minors from attending any services, rituals, or assemblies if done for the purpose of allowing the minor to identify with a purported identity
No, do not do that. Go,
inconsistent with
go,
the
go,
minor's
go.
religion.
Go horse.
Brief for Yale philosophers as Amici Curiae 10. No one would seriously dispute that such a rule classifies on the basis of religion. Whether the law prohibits a minor from attending any particular
Not really sure it's
religious
worth it
service
to fight
turns
this
on the
guy,
minor's
but I don't know,
religion.
maybe it'll
A
something
Jewish
valuable
child
to
can
fight.
visit a synagogue but not a church, while a Christian child can attend church but not the synagogue. SB1 operates in the same way. Consider the mother who contacts a Tennessee doctor, concerned that her adolescent child
that
has
still got
begun
me.
growing unwanted facial hair. This hair growth, the mother reports,
Wait,
has spurred
tell me how that didn't hurt
significant
him.
distress because it makes her child look unduly masculine. The doctor's next step depends on the adolescent's sex. If the patient was identified as female at birth, SB1 allows the physician to alleviate her distress with testosterone suppressants.
Ow, that
See
hurt.
Appendipet for Cert 266A,
Wow, I need to cook in this
describing
game
such
bad.
treatments, App 100.
I don't mean like
same.
hypothetically cook. I need to literally
What if
cook
the
food.
adolescent was identified male at birth, however?
Oh, that hurt.
SB1
I'm pretty much out of food
precludes
soon,
the
too.
patient from receiving the same medicine. Now consider the parents who tell a Tennessee pediatrician that their teenage child has been experiencing an unwanted, but medically benign, buildup of breast gland tissue. See Supra
Whoa, I got
at
my
3.
shit kicked.
Again, the pediatrician's next move depends on the patient's sex. Identified male at birth?
Ooh, this is good
SB1
reasoning.
allows the physician to prescribe hormones to reduce the buildup of such tissue. Yet a child identified as female at birth experiencing the same, or more, distress must be denied the same prescription. In both scenarios, SB1 provides that different treatment be accorded to persons on the basis of their sex, and therefore necessarily establishes a classification subject to scrutiny under the Equal Protection Clause. Reed versus Reed, 404 U.S. 71, 75, 1971. The Sixth Circuit apparently agreed. 83 of 4th, at 481, accepting the premise that the
I need to
status
just stop doing dumb
treats
shit in this
S
game, otherwise I'm
minors
going to get tired of
differently
it.
based on
Okay,
sex.
I'm going to move on. I'm not going to kill the
Tennessee,
hint.
too, essentially concedes
Oh,
the
I got to
point.
stop doing that.
It admits that a prohibition on wearing clothing inconsistent with the wearer's
Come
sex
on, Horace,
would
get me
trigger
there.
intermediate scrutiny, as would a law prohibiting professionals from working in jobs inconsistent with their
I don't know why,
sex.
but every time I load in, it's
Brief
raining.
for respondents 25.
I know that this biome is a
That is
biome that
because
has
for
rain,
some jobs
but
and some outfits, a
Oh,
male
yeah, look,
can
there's
have
a
the
storm.
job or
Every
wear
time.
the outfit, and a female cannot. IBID SB1 draws exactly the same kind of sex-based line. For some treatments that help adolescents look and feel more masculine, a male minor can have the treatment, and a female minor cannot.
again with this bullshit. You know what? I think the only option is for Link to just get naked.
That SB1 conditions a patient's access to treatment even in part on her sex is enough to trigger intermediate scrutiny. This court's equal protection precedents ask only whether a law differentiates on the basis of gender. Sessions v. Morales-Santana, 582
What, did I
US
go too far in a
47,
direction? There's no
58,
way. Oh, it's over here.
2017. If so, the law attract S. heightened review under the Constitution's Equal Protection Guarantee. IBID. A long line of this court's equal protection
Oh, I'm
precedents
getting
confirms that much.
My ass beat.
See Hibbs, 538 U.S. at 728
Hibbs.
S. Statutory
Previous court case.
classifications that distinguish between males and females are subject to heightened scrutiny. Virginia, 518 U.S. at 531. Parties who seek to defend gender-based government action must demonstrate an exceedingly persuasive justification for that action. JEB v. Alabama X.
This is easy.
TAB
Thank God. I'll take these over
511 US
pretty much anything, anytime.
127,
It's still just a minor test of
136,
strength. It's not even the hard kind.
1994. While gender-based classifications today Warren T. heightened scrutiny. That is why an Alabama statute
Direct
that
protection is pretty
authorized
stupid. I don't
is
like it.
The imposition of
Mephi's
alimony
Grace is pretty huge. I might
obligations
just
on
go get
husbands,
Mephi's Grace
but
next.
not on wives. Establishes a classification subject to scrutiny under the Equal Protection Clause. The plaintiff, Mr. or, comma, bears a burden he would not bear were he female. Or versus or, 440 U.S. 268, 273, 278, 1979. This
Oh, I got him
court's
before you
decision
even
in
got a
Bostock
single round
versus
in.
Clayton County,
Easy.
590 U.S. 644, 2020.
Can I not hold another
confirms the
item?
classification
Oh,
on SB1's
badly damaged.
face.
Go away then. Cool, a spear. I wish I could just get more of these shrines. These are easy.
SB1 is designed to force boys and girls to look and live like boys and girls. Brief for United States 23, urging that any suggestion of sex stereotyping is relevant only to whether a law that classifies on the basis of sex fails intermediate scrutiny.
Ooh.
Anti, F15. That argument ignores that a law policing a sex
Stereotype.
stereotype, like the hypothetical
Yep.
requirement that all children wear sex-consistent clothing,
This is why
can itself qualify as
Colorado just
sex-based
passed
government
the
action that triggers
Trans Bill of
intermediate
Rights.
scrutiny. See
I can
United
literally
States
see how it
versus
addresses
Virginia,
these topics
518
directly in its policy because I have
515,
read it in its policy.
531,
Because I attended one of the sessions in
Bostock
which
versus
we
Clayton
voted
County,
to
590
advance it,
U.S.
and then eventually get signed in.
644,
It did get a bunch of things cut out, though. But one of the
2020.
things I believe that were cut out was
The clothing law would tolerate from a female minor at least
no,
some
I believe it
behavior,
passed is that
wearing a
schools
skirt,
have to
for example,
offer,
that it prescribes for male minors and thereby treat minors
they can
differently
offer
on the
binary
basis of
clothes,
sex.
but they can't require a kid
In
to wear
any event,
one set
the
of clothes or
United States
another.
need not rest on a theory
Just as
of
long as
sex
the kid wears
stereotyping here because
one of the
SB1
uniforms, if that school has a
classifies by
uniform
sex
at
on
all.
its face.
All right,
As
how the
Bostock
hell
explained in the
am I
context
to get out of
Title
here?
VII's prohibition on employment discrimination, it is impossible to discriminate against a person
I
for
really do
being
mean that. How could I get out of
homosexual or
here?
transgender without discriminating against that individual based on sex. ID at 660. In deciding that discrimination based on incongruence between sex and gender identity was discrimination because of sex, Bostock asked the very same question our equal protection precedents do, whether changing the employee's sex would have yielded a different choice by the employer. ID at 659 to 660, CF Students for Fair Admissions Incorporated, 600 U.S. at 231, applying strict scrutiny to government actions that treat people differently on the basis of race. Point 9. The answer was clearly yes, for the simple reason that discrimination against transgender employees necessarily penalizes a person
Now, does this guy even
identified
have
as male
anything
at
that I
birth for
particularly
traits or
value
actions
having?
that it tolerates in an employee identified. 9. Justice Thomas and Justice Alito observe, correctly, that the Equal Protection Clause in Title VII use different words. Anti, at 8, opinion of Alito, J, anti, at 2, opinion of
I
Thomas,
have
J.
got to stop fighting this
Yet
thing
that
like this.
difference in wording does not
All right,
change
the only
that
option
this
is the
court's
battle
equal
axe.
protection precedents have always required courts to ask the same question this court considered in Bostock. That is, whether a law differentiates on
Got
the
'em.
basis of gender. Sessions
Another
v.
scimitar and
Morales-Santana,
a really bad spear.
582 U.S. 47, 58, 2017.
This is already broken.
To be sure, the constitutional analysis
scimitar, and I
diverges
guess
from
I get,
Title VII
you know,
once
the
a court
body parts. Those will be
identifies a
useful
law
later.
or policy that differentiates on the basis of sex. That is because the Constitution tolerates governmental differentiation on that basis if it survives intermediate scrutiny. Virginia, 518 U.S., at 533. Title VII offers employers
Oh,
no
hey, horse.
similar opportunity to justify sex
I'm
discrimination.
gonna go
so
teleport
the inquiry
back to
largely
Kakariko
concludes
Village.
once an employee establishes that she was treated worse
Let her
because
know
of
that I
sex
beat one of
or
the
another
divine beasts.
protected trait. C. Muldrow versus C. Lewis,
think, however, that our
601
facial
U.S.
classification is relative to
346, 354, 2024.
Oh, I see.
There is no reason to think, however,
It contradicts
that a facial
itself. It can't
classification
fit
like
under Title
SB1
VII
could simultaneously
and
be sex-based under
be
Title
sex neutral at the
VII
same
and
time.
sex-neutral under the Equal Protection Clause.
Man, if this had passed, that would have been a
See
great
General
court
Electric
precedent.
Company v.
Like a powerful
Gilbert,
one.
429 U.S. 125, 133, 1976, particularly in the case of defining the term discrimination, which Congress has nowhere in Title VII defined. Equal protection
20 pages
cases
left.
afford an existing body of law analyzing and discussing the term in a legal context not wholly dissimilar to the concerns which Congress manifested in enacting Title VII. as female at birth. Bostock, 590 U.S. at 660. Nor was it a defense to liability that the discrimination might apply equally to both sexes. An employer who fires a woman, Hannah, because she is insufficiently feminine and also fires a man, Bob, for being insufficiently masculine, in both cases fires an individual in part because of sex. ID, at 659. The same is true of SB1. By depriving
I'm gonna keep
adolescents
spamming
of
heart
hormones
containers.
and puberty blockers
I'd prefer
only
to
when
have
such
more
treatment
stamina,
is
but
inconsistent with a minor's sex.
I'm pretty good at
the law
using it sparingly.
necessarily deprives minors identified as male at birth of the same treatment it tolerates for an adolescent identified as female at birth, and vice versa.
Okay.
3. Notwithstanding that SB1 distinguishes between
Chicken.
males and females in the medical treatments
Chicken
it
jockey.
authorizes, the Sixth Circuit
Chicken,
declined
chicken.
to apply intermediate
Lava
scrutiny.
chicken. I'm gonna put the chicken
It believed
in the
SB1's
fire.
treatment of both sexes to be even-hand, D.
Chicken in the
83
fire.
of a fourth, at 479.
You can
meaning,
eat bird
in the
wings in this
panel's
game, but you
judgment,
just can't
the
eat chickens.
classifications were not invidious or unfair. ID, at 483 to 484.
Damn, who sells knight armor? Only in
Intermediate scrutiny,
Hateno?
of course, is how this court
north?
determines whether a particular sex-based classification is invidious or unfair.
Only in Hateno they sell
C.E.G.
knight armor?
Virginia, 518
Is that true?
U.S. at
don't remember that.
531. The Sixth Circuit thus effectively held that intermediate scrutiny did not apply to SB1 because it thought SB1 might well pass such scrutiny. Even the majority today does not endorse this circular approach. Though it skirts the Sixth Circuit's error, the majority rests its conclusion on an equally implausible ground, that SB1's prohibition on treatments inconsistent with a minor's sex contains no sex classification at all.
It is
Tennessee
crazy
Code
how
Section 68 to 33, 103,
how different of a game
A1.
Tears of the Kingdom feels.
As the statute's text
Like it
itself
shouldn't,
makes
but it
clear,
does.
that
It feels
conclusion is
very different
indefensible.
fundamentally.
How does the majority wriggle itself,
Easy.
and the Sixth Circuit, free of any obligation to take a closer look?
Selling all my other crap.
It abstracts away the sex classification on SB1's face, asserting that the law classifies based only on age and medical
Okay,
purpose.
I'm selling all my prior
The theory,
clothes.
apparently, is that SB1 is sex neutral because it simply allows doctors to administer puberty blockers or hormones to minors to treat certain conditions but not to treat gender dysphoria.
Yeah, some conditions but not
Ante
others is their
at 9.
reasoning.
Unlike a law that prohibits attendance at a religious service inconsistent with the attendee's religion,
I'm gonna keep listening
the
and run
majority
to the
says
bathroom real quick.
a law prohibiting the administration of specific drugs for particular medical uses simply does not trigger heightened scrutiny. Ante at 14. The problem with the majority's argument is that the very medical purpose SB1 prohibits is defined by reference to the patient's sex. Key to whether a minor may receive puberty blockers or hormones is whether the treatment facilitates the medical purpose of helping the minor live or appear inconsistent with the minor's sex. That is why changing a patient's sex yields different outcomes under SB1. Again, take the adolescent distressed by newly developing facial hair. Was the patient identified female at? Johnson, 515 U.S., 900, 911, 1995. That SB1 imposes sex-based classifications on Tennessee boys as well as girls does not resolve the equal protection problem. If anything, it exacerbates it. See Loving vs. Virginia, 388 U.S. 1, 8, 1967, W. E. Reject the notion that the mere equal application of a statute containing racial classifications is enough to remove the classifications from the 14th Amendment's prescription of all invidious racial discrimination. N. Birth? SB1 authorizes the prescription of medication. Male at birth? SB1 prohibits it. For truly sex-neutral laws, it is impossible to imagine a single scenario where changing a patient's sex yields a different result. To borrow from the majority's catalog of apparently benign medical use distinctions, imagine Tennessee allowed consumption of Dayquil to ease coughs, but not minor aches and pains. See ante, at 12. The regulated medical purposes, treatment of coughs, aches, and pains, are unrelated to sex, so a patient's sex will never determine whether she can consume Dayquil. All that matters is whether the patient has a cough. So too for New York's ban on assisted suicide, which the majority equates to SB1. Ante, at 10. In Vaco vs. Quill, 521 U.S. 793, 1997, this court subjected the assisted
maybe
suicide
busy day
ban
tomorrow?
to
I
rational
don't know.
basis review because it neither treated anyone
I'm gonna
differently
do
from anyone else nor
what is my
jar
habit in this
any
game,
distinctions between
and I'm
persons.
just gonna go upgrade my gear for like a
ID
long time.
At 800. In New York, the court explained
It's weird to play this game and not be playing it for the story, because I always play it for the story.
Suicide. Ibid. Yet unlike for SB1, neither
Again, I'm
sex
starting to
nor
get bored
any
of the
other
game. Like, I've kind of gotten to a point, and I'm like, oh, I should switch to a different game soon.
Could
But I
permissibly
can't tell.
hasten death from another prohibited from doing so. ID at 800 to 801. All that mattered was the patient's existing connection to life support systems.
Now, here's
Those
the issue. I
connected
don't remember
could
half
lawfully
of the Great
hasten
Fairy
death by
Fountains are.
discontinuing
I know one of
treatment,
them is near
while
a
others, who required a
near a
prescription
tower,
for
near
lethal
one of the towers.
medication
So
to
if I
do
just get
so,
every single
could not.
tower in the game,
The patient's sex
I'll find the
or
third
race
fairy,
or
but the
national
fourth fairy,
origin would never decide the outcome.
I don't remember.
SB1, by contrast, renders every treatment decision it regulates dependent on two things: a minor's sex identified at birth, and the consistency of the requested treatment with that sex.
Oh, why did I go this way? What
That
an
the
idiot.
majority finds a way to recast SB1 in sex-neutral terms is no evidence that SB1 is sex-neutral in the way hypothetical
I'm not
prohibitions
saving
on
you your
Dayquil
damn
or
chickens. I've done
assisted
it
suicide would
across
be.
generations, across video
Contra,
games,
ante,
since I was like
at 14.
14. I've been
The
saving
majority
your chickens
emphasizes
or the
that,
girls'
in
chickens,
Tennessee,
someone's chickens
no
in
minor may
Kakariko
be
Village.
administered puberty blockers or
I'm not saving
hormones
them
to
this
treat
time.
gender
I'm done.
dysphoria, while minors of any sex may be administered puberty blockers or hormones for other purposes.
I just like that to start
Ante
resetting,
at
so I have 3
13.
when I need them.
But nearly every discriminatory law is susceptible to a similarly race or sex-neutral characterization. A prohibition on interracial marriage, for example, allows no person to marry someone outside of her race, while allowing persons of any race to marry within their
My
races.
Guardian Shield is damaged?
See Loving versus Virginia, 388 U.S. 1, 9, 1967. The
No, it's
same
a
is true
bloopy.
of a hypothetical law
Oh, I got it.
prohibiting
Wow.
attendance at services
Cool.
inconsistent with a child's religion,
usually struggle to
while
do that.
allowing all children to attend religion-consistent services. See Supra at 11. Indeed,
start
the
spamming
majority itself seems to
fairies again.
recognize that laws prohibiting professions inconsistent with a person's sex, marriages, inconsistent with a person's race, or religious services inconsistent with a
Alright,
person's
big
faith
fairy
must
lady.
be
How we
subject
doing
to heightened
today?
review, even if rewritten as ostensibly neutral prohibitions on sex dash, race dash, and
No,
faith
I guess you
inconsistent
can't shoot a
behavior.
fairy.
See ante at 13 to 14.
Big lady, what is going
And although the
on?
majority insists
How we
that its logic
doing?
would not apply to the hypothetical religion-consistent services law, ante at 14, it offers no principled
I would
reason
need
to
princesses,
differentiate that
and
law
for
from
these I would need
SB1's
what?
prohibition
More,
on promoting.
oh, choo-choos, interesting. Okay,
Inconsistent
well, I'm gonna grab those
side
princesses
with the
from behind you, and then I'll be
patient's sex.
good.
B.
Recognizing,
Recognizing, perhaps, that this court already decided
The Great Fairies
in
Fountain
Bostock
theme,
that
going back to
discrimination
Ocarina,
based on incongruence
is, like,
between sex and gender identity
so
was
important to me,
itself
and like that,
discrimination
the sound
because
of this
sex.
song
The
and different
majority
versions
seeks
of
to
it
distinguish
genuinely
Bostock away.
allows me to relax in a way that is
Unlike in
material.
Bostock, the majority urges changing a minor's
So
sex or
listening to this does
transgender
not help.
status does not alter the application of SB1. Ante at 19. Again, it emphasizes that no medical
Hell
treatment
yeah,
under
big lady.
SB1 is actually doled out on the basis of sex, because, it says, medical treatment necessarily encompasses both a given drug and the specific
this is
indication
a
for which
dumb
it is being
question.
administered.
And the answer is
Ante
probably
at
that
12 to 13, 18 to 19.
I don't know, they're too lazy or too busy,
The
but like,
majority's logic is as follows.
why aren't we
If a
seeing actual
transgender boy
politicians,
who was identified as female at birth seeks testosterone
why aren't we
to
seeing
treat his
actual
gender
politicians do what
dysphoria,
I'm doing right now?
SB1 prevents a healthcare
Like, no joke.
provider
Like,
from
why are
administering
we
it
not
to him.
seeing politicians be like, hey, I'm
Ante
live
at
streaming me
19.
doing my job and reading
If
the
you change his
document.
biological sex from female to male,
You're going to get to see
the
my live
majority
reaction
says
to it.
SB1 would
And
still
what a
not
great way to
permit
reach
him
out
the
to younger
hormones he
people and get
seeks
them
because
involved
he
with
would
this.
lack a qualifying diagnosis for the testosterone.
I actually
such
really
as a
do wonder why they
congenital
don't also do
defect,
this.
Precocious puberty, disease, or physical injury. Ibid. As should
No, I'm
be
not gonna.
abundantly
Those aren't
clear
useful.
by this point, the majority's recharacterization of SB1 is impossible to reconcile
No way that
with
we
the
are only on
statute's
111.
plain
Let's
terms.
speed this up. I have stuff to do today. So.
Terms. SB1 allows physicians to prescribe hormones and puberty blockers to treat not just some defined category of cancers and rashes, but any physical or chemical abnormality present in a minor that is inconsistent with the normal development of a human being of the minor's sex.
Wait, where's Mount Lanayru? Mount Lanayru. There is a dragon up there,
If a
and
minor
I
has
want
some
it.
physical abnormality, say medically benign facial hair,
I'm gonna go
typically
save that
perceived as
dragon.
inconsistent with her sex identified at birth, female, SB1 deems it a congenital defect that physicians can treat. Change the patient's sex from female to male, and the law now forbids providing the same
Oh,
drugs
I
to rid
see
the
their
minor of the same
reasoning.
facial hair.
Right.
In other words, SB
So, wow, what a good reason of logic to deal with their batshit logic that they threw in the first place. Wow, okay, I get it. This is powerful logic. No wonder these people fucking know what they're saying. They're saying, like, hey, you say that this bill doesn't discriminate on the basis of sex because it bans transgender healthcare for all trans kids, no matter if they were a male or female or MTF or FTM or whatever. And these guys are like, what the fuck are you talking about? No, that's not the case. You're clearly banning, you know, if a kid were cis, meaning a girl developing facial hair, you would allow access to gender-affirming care, these exact treatments that Tennessee is banning. But were that girl born a boy, or things happen in the other direction, suddenly it wouldn't be allowed. Let me reread what they're saying here. Change the patient's sex from female to male, and the law now forbids providing the same drugs to rid the minor of the same facial hair. You're right. Yeah. No, I see what they're saying. Yeah, because, you know, getting rid of facial hair via drugs would be transgender healthcare if the girl were suddenly a boy. So they are logically, rhetorically, according to law and their legal precedent in stare decisis, they're ignoring the very obvious and clear fact that this does ultimately discriminate on the basis of sex in a material way. These Supreme Court justices have brains.
One makes explicit that the very reason why a doctor can treat an adolescent female for hirsutism, male pattern hair growth, but
Hirsutism.
not gender dysphoria, is that the
Hirsutism?
former will
I bet-
promote
I wanna
consistency
pronounce
with
it
sex,
hirsutism,
while the
but-
latter does the opposite.
You know, who knows?
CF Ante at 20.
Yep, the dragon is up
majority
there, and I
opinion.
have to find him.
As was true in Bostock,
I'm also
then,
freezing
the
to
law
death.
deprives minors of medical
Right now, I am
treatment
actively
based,
freezing
in
to
part,
death in the
on
game.
Sex. To be sure, when the hypothetical minor
Nope,
is
that does
male,
not help.
not female, the patient's diagnosis may well change too. The female adolescent distressed by facial hair might receive a diagnosis of hirsutism, while the male adolescent may be diagnosed with gender dysphoria. See Supra at 3,
Wow, that hurt.
11.
I
See
thought in the
also
snow it
Ante
was supposed to
at
have less
20,
fall damage.
Majority opinion. The same, however, was true in Bostock.
I will say in this
When
game,
an
one of the
employer
things I
fires
like
an
to do,
employee because
unironically,
she
is go hunting.
transgender, the court
I
explained,
like hunting
two
and then
causal
cooking,
factors
like the
may
whole
be in
process.
play,
It's nice.
The individual sex and the sex with which the individual
There was nothing in
identifies.
there. Oh my god, it was a Korok. I did not
US
need
at
that.
661.
Fuck,
Yet
why
so
did I
long
do
as the
that?
plaintiff's sex is one but for cause of that decision, the employer discriminates on the basis of sex. ID at 656. So too with SB1. Sex and diagnosis may both be in play.
So this is
ID
like a
at
mini boss fight practically, if I
661.
remember.
As long as sex is one of the law's distinguishing features, however, the law classifies on the basis of sex,
But
and
I
the
have to
Equal
save
Protection
him
Clause requires application of
by
intermediate
ridding him of the
scrutiny.
malice.
C.
Which now it's called
In a
Gloom in
final
the next
bid
game
to
for some
avoid
reason. I
applying
don't
our
really
equal
understand.
protection precedents, the majority asserts that mere reference to sex is insufficient to trigger intermediate scrutiny, especially in the medical context. Ante at 10. Of course, not every legislative mention of sex triggers intermediate scrutiny. A law mandating that no person, regardless of sex, can consume a dangerous drug, for example, would be subject to rational basis review. Yet SB 1 does not just mention sex. It defines an entire category of prohibited conduct
I got
based on
frozen.
inconsistency
Oops.
with sex. And it is hard to imagine a law that prohibits conduct inconsistent with sex that could avoid intermediate scrutiny. Nor does the fact that SB 1 concerns the medical context change the relevant
Oh, come on. There's
analysis.
no world in which Link would
If
dry
it-
fire a bow.
No one disputes that, yes, all
He would not
medical
do this.
treatments and
He
procedures
would not ruin
are
his own
uniquely bound
material.
up in sex, or that there are biological differences between men and women. Ibid.
Bozo.
That there are such physical differences is,
Play more.
after all, one of the reasons why sex is not altogether a prescribed classification. See Virginia, 518 U.S.
Love me some
at
Claymores in this game.
533. A law that allowed only women to receive certain breast cancer treatments, for example, might well be consistent with the Constitution's equal protection mandate if the state establishes
Oh,
that the
what
relevant
happened?
treatments are suited to women's, and not men's, bodies. CF Ante, at 11, noting many breast cancer treatments are approved for women only. Laws that differentiate based on biological distinctions between men and women are precisely the sort that states
Oh.
might successfully defend under intermediate scrutiny. Biological differences between the sexes,
Oh.
however, are no
Did he
reason
just
to skirt
throw
such
that?
scrutiny altogether.
How often do they ever throw
Fashioning
something like a
medical
sword at
context-only
Link?
exception also runs counter to decades of equal protection
that was
precedents.
weird.
This court has clarified that, although not every sex-based distinction is marked by misconception and prejudice, Tuan Nguyen v. INS 533 U.S. 53,
Yeah, I know.
73,
Using
2001,
that sword for
every
that was fucked
sex-based
up, but
distinction
whatever.
does warrant intermediate scrutiny. CJEEB 511
Finally
US
starting to run out
at
of arrows.
136.
I've used like a
Although
billion.
gender-based classifications today warrant heightened scrutiny, emphasis added. Take, for example, Tuan Nguyen, where this court assessed the constitutionality of a law imposing one set of citizenship acquisition requirements on children born abroad out of wedlock to U.S. citizen mothers and another on those born of U.S. citizen fathers. 533 U.S. at 60. The court ultimately decided that the different set of rules for fathers and mothers was neither surprising nor troublesome from a constitutional perspective, because
hurt.
fathers
Fuck.
and mothers are not similarly situated with regard to the proof of biological parenthood. ID at 63. We reached that conclusion, however, only after demanding of the government an explanation for why that sex classification. Serve D. Important
I will
governmental
save the
objectives and how the
dragon.
discriminatory means employed, or substantially related to the achievement of those objectives. ID at 60, quoting Virginia, 518 U.S. at 533. In no sense did the biological differences between the sexes relieve courts of the obligation to examine the sex classification with a careful constitutional eye. Nor is any medical context exception necessary because intermediate scrutiny itself allows the state to maintain classifications where justified
Hello,
by
Dragon.
biology.
I'm going to heal you as best I
4.
can.
Having blithely dispensed with the notion that SB1 classifies on the basis
Jesus,
of sex,
it's bad.
the majority next asserts that SB1 does not classify on the basis of transgender status. Ante, at 16. That too is contrary to the statute's text and plainly wrong. SB1 prohibits Tennessee physicians from offering hormones and puberty blockers to allow a minor to identify with a gender identity inconsistent with her sex. Tennessee Code in a section 68
Is she is Hylia talking to me?
Desiring to identify with a gender identity
She's talking to me.
inconsistent with sex is, of course, exactly what it means to be transgender. The two are wholly coextensive. See Oxford English Dictionary, 3D edition, December 2023, transgender, when used as an adjective, means a person whose sense of personal identity and gender does not correspond to that person's sex at birth. That is why it would defy common sense to suggest an employer's policy of firing all persons identifying with or living as an identity inconsistent with their sex does not discriminate on the basis of transgender status. Left with nowhere else to turn, the court hinges its conclusion to the contrary on the by now infamous footnote 20 of Geduldig versus Aiello, 417 U.S. 484, 1974, which declared that discrimination on the basis of pregnancy is not discrimination on the basis of sex. CID at 496 to 497 and 20. The footnote reasoned that, although only women can become pregnant, normal pregnancy is an objectively identifiable physical condition with unique characteristics, and lawmakers are constitutionally free to include or exclude pregnancy from the coverage of legislation on any reasonable basis, just as with respect to any other physical condition. Ibid. The takeaway, according to the majority, is that not every legislative classification concerning pregnancy is a sex-based classification, and so, apparently, not every legislative classification concerning gender incongruence, at least in the context of medical treatments, classifies on the basis of transgender
How exactly
status.
do I get up there to him?
ID.
Oh my god, we're in the middle of a blood moon while I do this?
Geduldig was egregiously wrong when it was decided, both, b, because pregnancy discrimination is inevitably sex discrimination, and because discrimination against women is so tightly interwoven
how the hell
with
did I just do
society's
that?
beliefs about pregnancy and motherhood. Coleman versus Court of Appeals of MD, 566 U.S. 30, 56 to 57, 2012. Ginsburg, J, dissenting. That the majority must resuscitate so unpersuasive a source, widely rejected as indefensible even 40 years ago, is itself a telling sign of the weakness of its position. C.S. Law, Rethinking Sex and the Constitution, 132. U.I.L. Rev. 955, 983, 1984, criticizing Geduldig has become a cottage industry. That the court today extends Geduldig's logic for the first time beyond pregnancy and abortion is more troubling still. Divorced from its fact-specific context, Geduldig's reasoning may well suggest that a law depriving all individuals who have ever, or may someday, menstruate of access to health insurance would be sex-neutral merely because not all women menstruate.
You got it, you got it.
In any event, even Geduldig's faulty reasoning cannot save the majority's conclusion that SB1 is innocent of transgender discrimination.
Oh, the berry saved me.
A desire to identify with or live as
he's clear, right? I've cleared this dude.
Inconsistent with one's sex, Tennessee. Code in section 6833 103 A1A is not some objectively identifiable physical condition that legislatures can target without reference to sex or transgender status. Geduldig, 417 U.S. at 496 and 20.
And now I'm getting the damn blood moon. This was an insane
people, by
night
definition,
in the game.
Identify with or live as a purported identity inconsistent with
just
their
happened?
Sex. Tennessee Code in section 68
a blood moon in the middle of that is
103
crazy.
A1A.
I'm skipping the blood moon. I don't want to watch.
So, unlike the classes of pregnant persons and women, the class of minors potentially affected by SB1 and transgender minors are one and the same. That SB1 discriminates on the basis of transgender status is yet another reason it must be subject to heightened scrutiny.
Yeah, I guess I can only get one of those at a
decided
time.
In Bostock that it is impossible to discriminate against a person for being transgender
oh, they still have something on the back of them. What the hell?
Individual based on sex, 590 U.S. at 660.
Well,
and
how am I
sex
supposed to catch up
discrimination is
now?
of course subject to heightened scrutiny. Nor should there be serious
what is still left on the dragon right now?
Persons bear the hallmarks of a quasi-suspect class. See Cleburne versus Cleburne Living Center Incorporated. 473 U.S. 432, 441, 1985. Describing the standard.
Okay, it's there on the tail. I don't know
Transgender
if I'm
people
going to be
have
able to
long
catch
been
up, though.
subject to discrimination in healthcare, employment, and housing, and to rampant harassment and physical violence.
Come on, Link,
Grimm
get
versus
there.
Gloucester,
You can
CTY.
do it.
School BD 972F 3D 586
There's
611.
absolutely no reason I should have to miss this shot in a
detailing that
moment.
history. See also K. Aberry, B. A. Farrell, J. Levi, and N. Banguri. A bare desire to harm transgender people and the Equal Protection Clause. 57 BCL Rev 507
we're good.
556 to 557.
What a cool purple
2016 describing Congress's
but then it turns
exclusion
blue, right?
of transgender people from the Fair Housing Act, Americans with Disabilities Act, and Rehabilitation Act.
I have to get the fuck back up there
Individuals
somehow.
whose gender identity diverges from their sex identified at birth, whether labeled
Please
as
tell me it's just gonna
transgender at
teleport
the
me
time
back
or
up there.
not, moreover, have been subject to a lengthy history of de jure discrimination in the form of cross-dressing bans, police brutality, and anti-sodomy laws. See, e.g., K. Redburn, Before Equal Protection, The Fall of Cross-Dressing Bans in the Transgender Legal Movement, 1963-86, 40L, and History Rev 679, 685, 687, 2022, Orlovsky, Vice Patrol 29, 108, 2021, W. Eskridge, Gay Law, Challenging the Apartheid of the Closet 328-337, 1999, Cataloging State Consensual Sodomy Laws, 1610-1988. Beginning in 1843, cities ranging from major metropolitan
offer
centers
the
such
scale,
as Chicago
apparently.
and Los Angeles to small cities and towns including Cheyenne, Wyoming and Vermilion, South Dakota enacted ordinances that, most commonly, criminalized any person
Okay, and now I get a shrine out of this, I think?
pair, ing, upon any public street or other public place, in a dress not belonging to
Yeah,
his
there
or her
we go.
sex. Redburn, 40L. And History Rev, at 687. In any
Oh, and I
event,
think these
those
typically give me
searching for
something really high quality, like
more
clothes or a
evidence of
special
de jure
item.
discrimination against transgender individuals, see ante, at 7 to 9, Barrett, J., concurring, need look no further than the present. The federal government, for example, has started expelling transgender service members from the military and threatening to withdraw funding from schools and nonprofits that espouse support for transgender individuals. Transgender persons, moreover, have a defining characteristic, incongruence between sex and gender identity, that plainly bears no relation to the individual's ability to perform or contribute to society. Cleburne, 473 U.S., at 441. As a group, the class is no more large, diverse, and amorphous, ante, at 4, opinion of Barrett, J., ante, at 14. Alito, J., concurring in part and concurring in judgment, than most races or ethnic groups, many of which similarly include individuals with a huge variety of
It's just a
identities
spear,
and
though. That
experiences,
wasn't really as hype
ante,
as I would
at
have
5,
liked.
opinion of Barrett, J.
Whatever.
Not all racial, ethnic, or religious minorities, for example, carry an obvious badge of their membership in the disadvantaged class. CF ante, at 16, opinion of Alito, J. But as evidenced by the recent rise
Oh,
in
at least I got a
discriminatory
spirit
state
orb
and
out of
federal
this.
policies and the fact that transgender people are underrepresented in every branch of government, Grimm, 972 F3D, at 611 to 613. Moreover, the class lacks the political power to vindicate its interests before the very legislatures and executive agents actively singling them out for discriminatory treatment. Sealing versus Castillo, 477
Which one of you
U.S.,
wrote this shit?
635,
This is
638,
quality.
1986. In refusing to say as much, the court today renders
Transgender Americans doubly vulnerable to state-sanctioned discrimination. Wow, the Supreme Court is saying that shit out loud.
SB 1's
Not that that's how they voted,
by
but
sex and transgender status clearly
the ones who
require
dissented
the
are saying that
application of
shit.
intermediate scrutiny.
It's pretty fire.
The majority's choice instead to subject SB 1 to rational basis review, the most cursory form of constitutional review, is not only indefensible as a matter of precedent but also extraordinarily consequential. Instead of scrutinizing the legislature's classifications with an eye towards
I wish the
ferreting
government
out
were required to put out
unconstitutional
documents like this every time
discrimination,
they
the majority
plan on going
declares
to
it will
war.
uphold Tennessee's ban as
They're
long
like,
as there is any
here's 100
reasonably
pages
conceivable
explaining
state
why
of
we
facts
chose to
that
what
could
we
provide a
did,
rational
and
basis for
everyone
the
gets to publicly
classification.
read it. I don't know, maybe if they do.
Ante, at 21,
Yeah, I
quoting
shouldn't
Beach
act like they don't.
Communications
Maybe they do.
Incorporated, 508 U.S., at 313, emphasis added. That marks the first time in 50 years that this court has applied such deferential review, normally employed to assess run-of-the-mill economic regulations, to legislation that explicitly differentiates on the basis of sex. As a result, the court never even asks whether Tennessee's sex-based classification imposes the sort of invidious discrimination that the Equal Protection Clause prohibits. The majority says that it does not want to second-guess the lines that SB 1 draws, ante, at 22, or to resolve disagreements about the safety and efficacy of medical treatments in an evolving field, ante, at 24. The concurrences, too, warn that applying intermediate scrutiny in this case may require courts to oversee all manner of policy choices normally committed to legislative discretion, including in areas of legitimate regulatory policy, ranging from access to restrooms to eligibility for boys and girls sports teams. Ante, at 5, 6, opinion of Barrett, J. See also ante, at 4, Thomas, J. Concurring,
Interesting.
highlighting the potential for basis for government action. Cleburne versus Cleburne Living Center Incorporated,
473 U.S. 432, 450, 1985. See also ante, at 6, opinion of Barrett, J. Recognizing that an individual law inexplicable by anything but animus is unconstitutional. High cost, high risk lawsuit.
Alright, I'm
S.
getting pretty tired.
Looking carefully at a legislature's proffered reasons for acting, as our equal protection precedents
just gonna
demand,
pause
is
and
neither needless second
try to
guess,
focus on
ing,
finishing out reading.
ante, at 22, majority
some stuff
opinion,
on my
nor
phone.
judicial encroachment on areas of legitimate regulatory policy, ante, at 6, opinion of Barrett, J. After all, closely scrutinized, ing, legislative choices is exactly how courts distinguish legitimate regulatory policy, i.e., from discriminatory ones. Ibid. Indeed, judicial scrutiny has long played an essential role in guarding against legislative efforts to impose upon individuals the state's views about how people of a particular sex, or race, should live or look or act. Women, it was once thought, were not suited to attend military schools with men. Virginia, 518 U.S., at 520 to 523, 540 to 541. Men and women, others said, should not marry those of a different race. Loving, 388 U.S., at 4. Those laws, too,
You know what I could
posed
do? I have a
politically
package
fraught
that I
and
need
contested
to,
questions about race, sex, and biology.
Get boxed up and ship out, so I'm
In
just
a
gonna
passage that sounds
do
hauntingly
that.
familiar
So I'm gonna
to
turn my
readers of
audio off and
Tennessee's
just
brief,
get this
Virginia argued in
boxed
Loving
up
that,
while
should this court
continuing to
intervene,
read.
it would find itself in a bog of conflicting
You'll get to see
scientific
me
opinion
wrap it, though,
upon
I
the
guess.
effects of interracial marriage, and the desirability of preventing such alliances, from the physical, biological, genetic, anthropological, cultural, psychological, and sociological point of view. Brief for Appellee in Loving v. Virginia, O.T. 1966, number 395, page 7. In such a situation, Virginia continued, it is the exclusive province of the legislature of each state to make the determination for its citizens as to the desirability of a policy of permitting or preventing such interracial alliances, a province which the judiciary may not constitutionally invade. ID, at 7-8. This court, famously, rejected the state's invitation in Loving to defer to the wisdom of the state legislature based on assertions that the scientific evidence is substantially in doubt. 388 U.S., at 8. In considering the constitutionality of Virginia's male-only military academy, 2, the court itself assessed that opinions of Virginia's expert witnesses that GM.Ls tend to need an atmosphere of adversativeness, while F.M.Ls tend to thrive in a cooperative atmosphere. 518 U.S., at 541. What the court once recognized as an imperative check against discrimination, it today abandons. Yet the task of ascertaining SB1's constitutionality is a familiar one. Tennessee has proffered an undoubtedly important interest in protect, the health and welfare of minors by prohibiting medical procedures that carry risks and harms. Tennessee Code in Section 68-33 of 101, 8b, e, see New York v. Ferber, 458 U.S., 747, 756-757, 1982, states interest in safeguarding the physical and psychological well-being of a minor is compelling. All, including the Solicitor General, agree that the state may strictly regulate access to cross-sex hormones and puberty blockers to achieve that purpose. See TR of Oral Arg 39-40, 152-153, agreeing that West Virginia's more tailored limitations on gender-affirming care would likely survive intermediate scrutiny. It may well be, too, that deference to legislatures is particularly critical in this context, where the provision of medical care to minors is at issue. Ante, at 22. Opinion of Thomas, J. But that does not change the court's obligation, as mandated by our precedents, to determine whether the challenged sex classification in SB1's categorical ban is tailored to protecting minors' health and welfare, or instead rests on unlawful stereotypes about how boys and girls should look and act. See Virginia, 518 U.S., at 533. Infusing that antecedent legal question with a host of evidence relevant only to the subsequent application of judicial scrutiny, as Justice Thomas would have us do, see ante, at 7-22, simply puts the cart before the horse. The present record offers reason to question, as the district court did, whether Tennessee's categorical ban on treating gender dysphoria bears the requisite direct, substantial relationship to its interest in protecting minors' health. Mississippi University for Women v. Hogan, 458 U.S. 718, 725, 1982.
Tennessee has offered little evidence, for example, that it is more dangerous to receive puberty blockers to identify with, or live as, a purported identity inconsistent with the minor's sex than to treat other conditions like precocious puberty. Why, then, does SB 1 prescribe the regulated medications to treat gender dysphoria, while leaving them available for myriad other purposes? So too is it difficult to ignore that Tennessee professes concern with protecting the health of minors while categorically banning gender-affirming care for even those minors exhibiting the most severe mental health conditions, including suicidality. The majority's choice to avoid applying intermediate scrutiny is all the more puzzling, however, because this court need not itself resolve these questions or wade into what it dubs the fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. Ante, at 24. The Sixth Circuit never even asked whether the challenged sex classification in SB 1 serves important governmental objectives or is substantially related to the achievement of those objectives. Virginia, 518 U.S., at 533. All the United States requested of this court was confirmation that intermediate scrutiny applied. Brief for United States 32. On remand, the courts could have taken due account of the recent developments that, according to the majority, underscore the need for legislative flexibility in this area, including a recent report from England's National Health Service on the use of puberty blockers and hormones to treat transgender minors. Ante, at 23. Yet the majority inexplicably refuses to take even the modest step of requiring Tennessee to show its work before the lower courts. This case presents an easy question: whether SB 1's ban on certain medications, applicable only if used in a manner inconsistent with sex, contains a sex classification. Because sex determines access to the covered medications, it clearly does. Yet the majority refuses to call a spade a spade. Instead, it obfuscates a sex classification that is plain on the face of this statute, all to avoid the mere possibility that a different court could strike down SB 1, or categorical healthcare bans like it. The court's willingness to do so here does irrevocable damage to the Equal Protection Clause and invites legislatures to engage in discrimination by hiding blatant sex classifications in plain sight. It also authorizes, without second thought, untold harm to transgender children and the parents and families who love them. Because there is no constitutional justification for that result, I dissent. Cite as 605 U.S. ______, 2025, 1. Kagan, J., dissenting. Supreme Court of the United States. Number 23 to 477. United
All right, now
States,
we are on
Petitioner
to
v.
just
Jonathan
Kagan's
SKRMETTI.
little section here. I mean, to summarize the dissent so far, right? They made a couple of actually really good arguments. That argument about how, the majority here that are going to allow transphobia at the state level, the majority was like, oh, when we used to do 14th Amendment stuff with the sexes, it was always about, seeing if the discrimination was targeted on the sexes, not effects of the sexes, like pregnancy, which is an effect of one of the sexes. And they would always say, oh, well, pregnancy is an effect of the sex. So if you're discriminating on pregnancy, you're not discriminating against women, you're discriminating... Yeah, it's just stupid, right? And so they were like, well, here's the thing. It's like, the bill bans trans health care regardless of if you're a boy or a girl, and we don't count trans as a sex, so it's completely legal. Whereas the dissent is saying, actually, it really obviously... does have an argument that it discriminates on the basis of sex, because you could have a girl who's developing facial hair take hormones legally, and that will be the case after this bill. A girl who is developing facial hair, an AFAB girl, assigned female at birth, female girl, could be developing facial hair, which is called hirsutism, and could access medicines to really limit that, and that would be completely legal as a minor in the state of Tennessee. But if for some reason she were magically born as a male, it would be a no to want to take medicine to affect the development of facial hair on that now male person. So it's obvious really obvious that it does technically discriminate on sex, and also it's pretty plain that transgender people are a category of person that are actively being discriminated against, and the choice of the Supreme Court to not ally themselves on the side of egalitarianism is obvious, disgusting, stupid, terrible, and terrible for trans people. Now we're moving on to the last dissent, which looks like it's literally 2 pages, which is Justice Kagan's dissent.
Justice Kagan, dissenting. For all the reasons Justice Sotomayor gives, Tennessee's SB 1 warrants heightened judicial scrutiny. See ante, at 9-27, dissenting opinion. That means the law survives if, but only if, its sex-based classifications are substantially related to the achievement of important governmental objectives. United States versus Virginia, 518 U.S. 515, 533, 1996. As Justice Sotomayor notes, the point of applying that test is to smoke out invidious or otherwise unfounded discrimination. Ante, at 10, Michael M. v. Superior Court, Sonoma Situa, 450 U.S. 464, 469, 1981, plurality opinion. More concretely put, heightened scrutiny reveals whether a law is based on overbroad generalizations, stereotypes, or prejudices, or is instead based on legitimate state interests, such as the one here asserted in protecting minors' health. Virginia, 518 U.S., at 533. Because the court is wrong in not subjecting SB1 to that kind of examination, I join part I through 4 of Justice Sotomayor's dissent. I take no view on how SB1 would fare under heightened scrutiny, and therefore do not join Part 5. The record evidence here is extensive, complex, and disputed, and the Court of Appeals, because it applied only rational basis review, never addressed the relevant issues. Still more, both the plaintiffs and the government asked this court not to. 2 United States v. SKRMETTI. Kagan, J., dissenting. Itself apply heightened scrutiny, but only to remand that inquiry to the lower courts. So I would both start and stop at the question of what test SB1 must satisfy. As Justice Sotomayor shows, it is heightened scrutiny. I respectfully dissent.
Is that it? Was that the whole document? It's just saying, hey, I have no comments on how this would fare if we tried it differently? That's the document. I'm done. All right. I have now read the complete Supreme Court of the United States opinion on the case called United States versus SKRMETTI, Attorney General and reporter for Tennessee. I don't know. What are the... I'm going to be taping up this box while I try to summarize my thoughts. I don't know. What are the obvious things? The majority opinion believes that transgender people are not a protected class. The majority opinion believe that transgender people's identities have nothing to do with sex, thereby inferring that the Supreme Court of the United States acknowledges that gender and sex are 2 different things. The majority used a bunch of Supreme Court precedent in which it was legal to discriminate on the basis of age and discriminate on the basis of sex, so long as it's not discriminating the sexes against each other. It's only discriminating on something that a sex experiences, like pregnancy. I believe that was the Alilo, I don't know how to say it. Alio? Alio, I don't know. That one Supreme Court case precedent. So, yeah. What does this mean? This means there is now official Supreme Court precedent that transgender people are not going to be recognized under the law as a protected class. There is now Supreme Court precedent that transgender people's identities have nothing to do with the 14th Amendment's definition of sex and the protections of the sexes, essentially kicking transgender people out of having any hopes of ever developing any protections under the 14th Amendment, which is the one equal protections amendment the U.S. really has. And a few Supreme Court judges, it looks like 3 to 4, 3 of them, don't fuck with that logic and think that this is bad, but 6 of them concur that transgender people are not a protected class and should not be considered a protected class. They concur with the rhetoric of the original bill, which is that banning trans healthcare isn't a matter of discrimination against trans people. It's a matter of discrimination of treatment, even if that treatment is literally just for one specific group. Much like the California insurance ruling they kept noting, it's not direct enough to really constitute true discrimination, and even if it were true discrimination, it wouldn't particularly matter because transgender people are not an officially protected class under the U.S. Constitution of the 14th Amendment. So, trans erasure bill. I don't think that's hyperbolic at all. I actually just think that's like a normal definition of the bill. Like, yeah. This is pretty fucked up. And also, we're trying to go to war with Iran right now. Also, my fiance got arrested at a protest, completely innocent, 6 days ago. She got arrested at a protest. Didn't even come as a protester. She just came with me as a journalist to document the protest. And she literally just sat to the side while everyone else was actually protesting. She just sat at the state capitol. And then the police came in, and she tried to leave on her bike, abiding by the clear dispersal order that was communicated through behavior, but not through direct orders, because no one heard them say disperse. And anyone who arrived at the protest late would have no fucking clue. So the United States is currently saying transgender people aren't people, trying to start a hot nuclear war with Iran, and arresting random protesters that had nothing to do with the actual protests. That's the state of the United States right now. That's fucked up. We should do a revolution. Have a good day. Thank you for watching. Stay woke. Let's reclaim the word woke. What does woke mean? Woke means like being privy to issues. Stay privy. Stay aware. Stay reading. Stay up to date. Do not stay feared. Do not stay afraid. Do not stay withdrawn. Because every inch you give a fascist is a mile next that they can advance. And we have to do something before it is too late. Say the quiet part out loud. Goodbye.